Ladies and gentlemen, good afternoon. It is so good to see so many of you here today. Without further ado, we are going to call this matter to order, and we will call upon Her Honor, Schrader Ferguson, to come and give the invocation. Vice President, Her Honor, Schrader Ferguson.
Good afternoon. Please stand for the prayer. Let us pray. Almighty God, we gather here today in solidarity and in recognition of the importance of unity in peaceful conciliations, negotiations, and settlements, advocacy, and judgment. We thank you for one more occasion to assemble in fellowship with one another. Father, we ask that you bless us with your presence today, and further that you daily imbue us with the wisdom, knowledge, and understanding that we require to execute our various duties. Lord, May we labor in faithful obedience to your planned purpose and predestined call and assignments. Graciously ask that you grant us the love, humility, compassion, and mutual respect necessary to perform optimally in our respective roles. May we strive every day to be faithful stewards of the gifts and talents that you have so bountifully bestowed to us. May we view each person as brothers and sisters, and may we co-labor with one another in furtherance of the gospel, and as a peaceable and labor-friendly people. Father, it is my prayer that you bless these proceedings. God, kindly bless the Minister of Labor, President, Vice President, Director, attorneys, labor advocates, union employers, employees, and all other stakeholders in the labor vineyard. May we each leave here today with the renewed sense of purpose and understanding of that which you have required us to fulfill, both individually and collectively. May we faithfully discharge our sacred oaths and other contractual obligations. May we adhere to the rule of law and emphasize the importance of administering justice at every tier of the labor machinery. May we always be keenly aware that we shall give an account for our stewardship. Father, may we not be found to be wanting. This is my prayer in Jesus' name. Amen.
Thank you, Vice President Humes Ferguson. As you know, it is customary in Bahamian culture that we start every event with prayer. And of course, after prayer comes the welcome brought to you by none other than our Vice President from our Northern District, Mrs. Helen Almarales Jones.
Good afternoon. On behalf of the President of the Bahamas Industrial Tribunal, Mrs. Indira Demerit Francis, and Vice President Sarada Humes Ferguson, Ingrid Cooper Brooks, and our own Rihanna Godet Delaveau, and the tribunal staff, we extend a warm welcome to you to the Bahamas Industrial Tribunal's third annual Day of Solidarity seminar on this Monday, 21st November 2022. This day of fellowship and learning has been made possible with the cooperation of the Bahamas Bar Association, the Ministry of Labor and Immigration, the Bahamas Chamber of Commerce and Employers Federation, the Trade Union Congress, and the National Congress of Trade Unions of the Bahamas. We are happy to welcome our distinguished presenters, the Honorable Keith Bell, Minister of Labor and Immigration, Justice of Appeal, and I believe Mr. Bell is going to be represented today by the Acting Attorney General, Mr. Jomo Campbell. We have Justice of Appeal, Honorable Madam Justice Maureen Crane Scott. We have Mr. Kevin Demerit, Central Bank External Relations Officer, Mr. Robert Farquharson, Director of Labor, Mr. Sharon Martin, Chairman of the National Tripartite Council, and especially our international dignitary and keynote speaker, who will be joining us today virtually, Director of the International Labour Organization, whom we all better know as the ILO. He's their Decent Work Country Program Office for the Caribbean, Mr. Dennis Zulu. Under the team Evolving Industrial Relations for Changing Times, we look forward to an exciting time filled with interesting and educational presentations. So let's get it started in here. Welcome and enjoy.
Let's get it started hot. All right, then. So we're going to do exactly that and invite our Director of Labor, the esteemed, most excellent, most wonderful friend and comrade, Mr. Robert Farquharson, to come and share with us on his particular topic on industrial relations. Please welcome our Director of Labor.
Madam Vice President and our esteemed MC today, to our distinguished President and other Vice Presidents of the Tribunal, our distinguished ministers, Acting Attorney General, the Honorable Jomo Campbell, our esteemed visiting Head Justice, our Director of the Regional Office of the Caribbean, distinguished ladies and gentlemen, good afternoon. I am so pleased to have been given an opportunity to say a few words on the topic industrial relations in a changing environment. We pay tribute today to our honoree, the late Sir Randall Fox, who is considered the father of the modern trade union movement in the Bahamas. But for him, we would not have been here today. This afternoon, I'm going to make an attempt to. That's what I'm going to make an attempt to try to put in perspective 3 periods of industrial relations here in the Bahamas, and to give you, in my opinion, the way forward on what's our steps ahead. Um, in this presentation, okay, we're going to look at the components. We're going to look at the components of industrial relations. We're going to get a definition for industrial relations. We're going to look at the components for industrial relations. And we're going to look, in my opinion, at 3 times where industrial relations really was the center of the growth and the development of the Bahamas. And then we're going to try as best as possible, as time permits, to answer a few questions. The dictionary describes industrial relations. It refers to all types of relations between employers and workers, be they at national, regional, or company level, and to all dealings with social and economic issues, such as wage settings, working time, and just general conditions of employment. This is a very wide definition. It's widely accepted by most of the stakeholders and the players in the industrial relations environment. The International Labor Organization defines industrial relations and says industrial relations deals with relationships between either state and employers and work organizations, or relations between occupations and organizations themselves. What does this mean in reality? In the world of work, industrial relations is critical. You must develop a amicable relationship between the employers represented by capital, the workers represented by labor, and the state, which is responsible for the regulation of the environment. Um, Nothing can move in the country if we have an unstable industrial relations environment. Investors will stray away, workers will be discouraged, employers will not be profitable, and the country can actually come to a standstill if a stable industrial relations environment is not present. And it is that in that context that I speak to you this afternoon. There are a number of factors that makes up the industrial relations environment, components we call them, eh? Labor relations, that's how we talk each other. Relations between employers and executives, not because you are an employer, you have all of the answers. There must be a relationship between an employee and employer. My minister said to me a couple of weeks ago that when he served as chief of the Royal Bahamas Police of Intelligence Branch, he used to invite all of the members of his department in his meetings, strategy meetings. And he said that they even invited the custodial staff and the receptionists. And he said one time they was talking about an operation, and all of the superintendents and senior police officers were scratching their head how to solve the problem. And so the custodian raised up his hand and made a recommendation. And it was that recommendation that caused the operation to be a success. So everybody must be a part of it. Human resources management, that's a specialty in itself. How do you treat humans? How do you treat your fellow workers? How do you treat your subordinates? It's critically important. The trade union activities. Sad to say, we have to deal with this every day, and with all of the esteemed trade unions in our midst today, this is critically important. The concept of collective bargaining is enshrined in the statute laws of the Commonwealth of the Bahamas, and it's so critical to the growth and development, not only of the enterprise, not only of the government, but of the country. The freedom to negotiate ILO Convention of 98, critically important. Then you have to comply with all of the regulatory and statutory obligations. In the Department of Labor, we have developed a hotline, and our hotline has been ringing up the hook, primarily because both workers in some instances, but mostly employers, just do not abide by the simple regulatory and statutory requirement. We have people right now today, Bahamian employers, who are refusing to give women in this country the statutory maternity leave. Section 10 of the Employment Act speaks about overtime pay. We have companies in this country today, in 2022, refusing to make overtime payments as outlined in the law. And that's what good industrial relations does. In the early years, let's talk about the early years. And I got it, the early years is from the period of 1942 to about 1990ish, around that time. And one of the critical events that marked the birth of the modern trade union movement was the Burma Road riot. The first trade union was organized in the Bahamas around 1866 in Inagua, but it wasn't until around the early 1940s when there was a merger between the Bahamas Labor Union and the Bahamas Federation of Labor, and they merged into one organization. And this really was the beginning of modern industrial relations. They were able to, and you'll see in a couple of minutes how they was able to negotiate the first, what we call PERC, the first collective bargaining per se in the modern Bahamas. The early years, like I indicated, on June 1st, 1942, there was what we call in Bahamian history known as the Burma Road riot. This riot came about because the oppression of Bahamian workers on the construction of the airport. Um, it is probably the birthplace of the modern Bahamas. And a result of the demonstration, the workers are looted downtown, the riot act was read. And if you read the history book, you would see some significant things came out of it. There were four demonstrators that were killed. There were a number of them were seriously injured. 40 received managed, 128 were arrested, and 114 were convicted. All because a company was prepared to pay an increase in salary, and the government of the Bahamas at that time said no. Think, think about that. The company was prepared to give the increase, and the government of the day said no. What are the results of that, eh? The fundamental result of the day was that the government granted the first increase of 1 shilling per day and the first fringe benefit of a free meal for lunch for workers who was working on the project. In addition to the things that happened to the workers personally, there were a few changes made in our development. Labor legislation was brought in with the modern standards. The life of the House of Assembly was reduced from 7 years to 5 years. That's what it is today. And the universal suffrage was introduced, one man, one vote, all because of the working people of the Bahamas took a stand and said no. Yeah, just a photograph I put up. I'm sure you were seeing this before. That's the kind of march we had to do. I wasn't there, but that's the kind of things we had to do back in 1942 to get industrial relations where it is today. Why, Mr. Ferguson? How far we've come? Let's look at the second period. I call it the early years, Part two. This speaks about the general strike that is so famous in our history. And the general strike actually started in November of the preceding year, 1957. And it was about the taxi cab drivers who determined that it was wrong for the government of the day to give the tour operators exclusive right to transport visitors from the Nassau International Airport to the hotels, the Cable Beach and downtown. There was an 8 week truce. And after the truce, the government said, regardless of what you all say, regardless of what the workers say, we could give this exclusive right to the tour drivers. Well, there was a gentleman by the name of Sir Clifford Darling and a gentleman by the name of Lyndon Pinlan. They decided otherwise. And somebody decided that they will take the keys of every taxi cab driver, they will park it at the airport, they will block the airport, and they will take the keys uptown. Wow. Let's not forget how important it is to take a stand. As a result of that, let me tell you what has happened. Me, I serve as the director of the Department of Labor. The establishment of the Department of Labor came about as a result of that demonstration. The removal of the statutory restrictions on hotel and agricultural workers to organize, that's thereby the birth of the Bahamas Hotel Catering and Allied Workers and other unions. Then they talk of the setting of the Transport Authority. That's the Ministry of Transport today, all because of what workers had to do. Let's talk about, and there are some pictures. The first picture to the left is a photograph of the soldiers, the British soldiers that were brought in from Jamaica for the riot. Uh, we're talking about the general strike for 19 days. People ask me what the fuck is, and how you know about the general strike? A gentleman by the name of Clifford Dallin, who was then, Sir Randall Fox, who was the president of the Bahamas Federation of Labor, and then the father of our modern Bahamas still independent. The first hotel they attracted was the Emerald Beach Hotel. That's where the Sandals is now for today, for who don't know. And Sir Randall told me sitting on his living room, says, Mr. Farquharson, say, we decided that in order to facilitate the strike, we could use one word. The word was now. And Sir Randall and Sir Lyndon went in the Emerald Beach Hotel where the housekeepers was, phone bill people, and they said now. And they stopped at every hotel on the Cable Beach Strip, and they walk in, they said now. And every worker from every hotel and every business walk up the job. That's the power of the working people. We need that today, ladies and gentlemen. That's what it is back then. That's what it was back then. There were some other strikes. In 1981, the Bahamas Union of Teachers had a major strike that crippled the education system. In 1982, the telecommunication workers had a major strike that crippled the telecommunication sectors. In the early years, the relationship in industrial relations was considered combative, aggressive, hostile, and confrontational. Thank God, ladies and gentlemen, those years are now past. I call the period from 1990, to about 2017, I call it the stabilization period, And a significant effort was made to establish a win-win situation in industrial relations, climate by all of the stakeholders, the government representatives, the worker representatives, and the employer representatives. There became the emergence of powerful umbrella trade unions, the Commonwealth of the Bahamas Trade Union Congress, and the National Congress of Trade Unions Bahamas. We have their leaders here represented here today. There was an implementation and enforcement of international labor organization standards and conventions and protocols. Anytime the government of Bahamas would have become a member of the ILO on May 25th, 1976, and they were committed to a number of conventions. So every time employers or government tried to raise the ugly head and bring industrial relations to unstabilization, it was the trade union movement that says, okay, but ILO conventions say this, and ILO 98 say this, and ILO 144 said this. And this is how it was that focus that caused us to have a more cooperative rather than combative relationship in industrial relations. The government committed to the ILO Convention 144, which speaks to social dialogue. And it was a social dialogue concept that on the 15th of March in 2015 caused the enactment of the National Tripartite Council Act. Today, that act sets the standard of how industrial relations operate in the Commonwealth of the Bahamas. There was a number of increased legal action taken by the worker and employers organization. Let's not forget now, although they were less combative, trade unions couldn't go no more and just demand certain things. We had to be smart. I'm a fellow trade union, so please forgive me, ladies and gentlemen. And I just want to recall a couple of them. I used to work for the BTC, and back in the days, whenever we had a problem in BTC, the fellas them used to go underground and cut all the phone cables, and all the phones went off. But today, they got telephones with satellite. How you cut a satellite link? So you have to think differently. When there was a problem at the Sandals Hotel, and there was a dispute internal between the Bahamas Hotel Catering and Allied Workers Union and the Bahamas Hotel Maintenance Union. My brother and colleague, my mentor, Mr. Obi Ferguson, took that case all the way to the Privy Council and won the case on behalf of the workers. So our strategy had to change. Our strategy about walking off the job had to change. The workers couldn't be just about all for me, no more. What about the organization? What about the employer? The employer has some rights too. The employer has to make a profit. The employer has to run their business. They have to be free to run their business. But this must be a concept of mutual respect. And it was actions like what went to the Privy Council that cost and many other cases went to the courts. But it was just the focus on trying to settle disputes and issues without having to resolve to work stoppages. We were stabilizers in that time. Thank God for that stabilization period. And then I want to speak very, very briefly on industrial relations now in the Bahamas, now and later. There has to be a development and adoption of real partnership I call this, yes, true partnership period, eh? You don't have to talk partnership, you have to demonstrate partnership. The adoption of real partners by all stakeholders. The National Tribal Council, as I indicated, is considered the forum for labor and industrial relations in our country. It is the place where whenever there is an issue, whenever there's any Section 4 of that act outlines, I think there were 16 or 17 objectives of the council. It goes from dealing with the International Labor Organization to drafting legislation and making recommendations to the government. It is that concept of partnership that should be the catalyst for industrial relations in our country today. And of course, we are so pleased that through the NTC, we have been able to establish, and we're in the first phase of the implementation of the second generation Bahamas Decent Wage Country Program, 2001 to 2026. That's the error. I apologize for that. This second generation program is going to set the standard. It's going to be the model for which Caribbean countries follow on how to deal with industrial relations in a changing environment. The memorandum of understanding historically signed, I think it was August the 15th, Mr. Ferguson, last year, where the government, who was not a government at the time, committed in writing that we will do this. And the trade union movement said, we will do this. A veteran trade union for 30 years, we cannot think now about every time we have a problem, shutting the country down. We have to stop that way of thinking as trade unionists. We have to commit to things in writing that was done in memorandums. And whenever there's a problem, let's go around the table and let's solve the problem. Our country will never grow if we don't have that partnership concept. There were a number of lessons learned from the COVID-19 pandemic. Eh? The National Tribal Council, we developed a whole decent wage country program during COVID. Well, you know what we learned during COVID? Everybody going home. People was working from home for days and weeks and months. COVID is over and people are still working from home. What does that mean? We don't necessarily need brick and mortar to do our jobs. We don't need to be in the workplace to do our jobs. A whole new sector is being developed. A new workplace is being developed. So industrial relations itself have to change. And we have to change, taking in mind that you may not think about it. The employer don't need you there no more. But they really don't need you in the Bahamas no more. You ever thought about that? They can hire a Bahamian who live in California to do your job what you do in the Bahamas. Many of the banks, the telecommunications company right now, when you call their numbers, you know who's answering them now? Barbadians and Jamaicans. What does that say? The whole concept of the work has to change. The world of work itself has to change. In 2017, significant amendments were made to the 2017 Employment Act and the Industrial Relations Act after recommendation from the NTCA. It changed the very concept of what we do and how we look at the world of work. There has to be a commitment to continuous and ongoing education and training. No longer can trade unions today go to the bargaining table and demand 25% increase in salary. You better know how to read financial statements. You better know how to look at books. You better know to say, this, if this company been making a loss for the past 5 years, how could you ask for salary increase? The employers, okay, you just start sharing information. You can't keep them books hide all the time and expect trade unions to say, no, no, no. Share information. The Code of Industrial Practice and the International Relations Act says you must share information, particularly financial information. That's critical to growth and development of any society. It is so important. When I was president of the BCPOU, let me give you 2 examples. BTC was the monopoly on telecommunications. And when the then CEO, Mr. Leon Williams, developed this partnership with us, we was able to go into board meetings and we was able to look at all of the financial statements and all of the management accounts. So when we went to the bargaining table and said, we want a 25% increase in salary, and Mr. Williams opened the books for us, and we showed their projections over the next 5 years, we ended up with a 5% increase over 3 years. Because we understood there's nowhere in the world BTC could give 2,600 people a 25% increase over 3 years. The company will die. We had to bite that bullet and understand. Another thing we had to do too, we had to understand that we had to work with BTC to grow the pie. We need to come to work and come to work on time and do what we're being paid to do. Very, very important. And the Broadcasting Corporation of the Bahamas, when we went to the bargaining table with ZNS, the government was able to share information with us and said ZNS wasn't generating enough revenue to make the payroll each month. The government had to inject $250,000 each month into ZNS just to make the payroll. So how could a union go to the bargaining table and ask for 50% increase? You know what I asked for? I asked for productivity bargaining. I asked for the only way we get a raise is when we produce more than we expected to produce. That's how we have to think today to have a stable industrial relations climate, ladies and gentlemen. We have to think about decent work. The ILO speaks about decent work. What is decent work, eh? Decent work is the employment that respects the fundamental rights of human person, as well as the rights of workers in terms of conditions, work, safety, remuneration. If we do that, ladies and gentlemen, if every player in the industrial relation climate in this country shoot for decent work for all, and we use this guiding principle, all stakeholders must be committed to promoting fairness in the workplace by strengthening the partnership between employers and employees, by demonstrating mutual respect and a shared national focus. That's the changing minds of industrial relations. If we do that, we'll grow this Bahamas from strength to strength. Thank you very much, ladies and gentlemen.
Thank you very much, Director. You can easily tell that Director has a wealth of knowledge and information and experience, and we thank you for sharing that with us. Ladies and gentlemen, if you would look at page 6, you can easily see that our program has sort of morphed into a life of its own. And in order to accommodate certain unforeseen eventualities, we have to go with the flow. And without further ado, we will welcome the Honorable Jermo Campbell to render his thoughts and perspectives on labor relation. And at the same time, the Honorable Campbell will also extend courtesy to Mrs. Rosalie Fox by way of presenting to her the plaque in honor of her late father, Sir Randall Fox. We now welcome the Honorable Jermo Campbell.
Good afternoon, everyone. It is indeed my esteemed pleasure to bring brief remarks on behalf of the Minister of Labor and Immigration, the Honorable Keith Bell, who at short notice could not be here. Today's topic is indeed a timely one, and after the opening ceremony this morning at the Industrial Tribunal and the opening of its fifth court, I am pleased to say that it is indeed a day of solidarity and a step in the right direction. And again, I wish to thank Madam President and her colleagues on their efforts, and I pray them every blessing moving forward. This administration is committed to fostering an environment for stable industrial relations in our country. This relationship is critical to the growth of the Bahamian economy, and our administration realizes this and is committed to ensuring that all stakeholders are included and consulted in the decision-making process. With this in mind, the Ministry of Public Services has created a special unit to address all industrial relation issues and to seek to have them resolved on an expedited basis. It is important to note the signing of the Memorandum of Understanding with the trade union movement, which seeks to address matters and concerns and to be more responsive to the issues that impact workers in our country. I am therefore happy to say that there is now a commitment to regular and consistent meetings with social partners, including employer organizations and civil society, coupled with widespread consultation on proposed legislation and input from all stakeholders. With this in mind, We hope to advance labor relations in this country and ensure that, as Madam President indicated earlier, we do not become victims to the principles outlined in the book of Deuteronomy, chapter 24, verse 14 through 15. In conclusion, I pray that this day of solidarity grows into weeks, months, and years of solidarity so that we can continue to move our country upward, forward, onward together. Thank you.
Thank you. And would Ms. Rosalie Fox please come forward? Minister, if you would present the plaque. And we call upon Madam President. Mrs. Fox.
Is there a microphone?
Yes. I'll take that one.
It is indeed a pleasure for me to be here today. I must admit, when I received the invitation on Friday, I didn't quite know what to expect. And even in coming here, I wasn't quite sure where to go. But I got somebody to bring me, and so I arrived in time. I want to thank you for the honor, the beautiful plaque that you have given to me today. As always, when my father is recognized, I always feel if only he could be here. But hopefully he is a part of that great cloud of witnesses and he is able to see all that is taking place here on earth. Guess I'll take these off. Everything's fogging up. So before I express appreciation for the honor that is being given to Sir Randall, I would like to thank Mrs. Cadet and the Industrial Tribunal for the invitation. A few hours ago, she wrote, and kindly gave me an opportunity to say what it was like to be an eyewitness to history. To be honest, to do justice to that topic, I would need to be the main speaker, and that I am not. However, all is not lost. I have documented my story. When my father died 22 years ago, I really didn't know very much about the trade union movement. He tried to interest us, all along. But after his death, people started inviting me to come and give presentations and talks. And I used to say, I don't know anything. I was just born in 1953. And so they said, man, you must know something. And I found out I knew a lot. And at the point of his death, when we were trying to get a program together, we were able to open his library. And every inch of floor space was covered with boxes and papers and records and documentation. And it was at that point that I knew I had a new job awaiting me, that information had to be preserved. And for 22 years, I have been scanning and documenting and putting the information out there for the general public. And it was on Saturday night, I decided I would look at the filing cabinet, and I looked at the drawers, and I saw so much. I mean, just literally hundreds, if not thousands, of documents that have yet to be touched. And I said, I became frightened. I wondered, will I ever finish? But I will continue on, I will persevere. But as I said before, all is not lost. I have documented my story. You know, I'm not too familiar with these little devices. You press something and everything vanishes. But I have documented my story in a well illustrated electronic book titled A Call to Serve. And I will send the link to Mrs. Gadet, or you can send me a message on Facebook, and it will be yours for the asking. Now, I would like to say that my story is not a carbon copy of The Faith That Moved the Mountain. It's a different perspective. A child growing up under British colonial regime. And so I think you will find it quite fascinating. I have put it in circulation, and people have, given me good reviews. But on behalf of the Fox family, I am indeed grateful to receive this recognition presented to my father today. His, indeed, is a fascinating story, which I was not fully aware of because so much that happened to him occurred when I was at a very young age. However, he documented his life so meticulously that since his death 22 years ago, and in an attempt to preserve the historical record, I have become a scholar of labor history. For those who are unaware of the archives that we, his children, have created for him, please make time to visit his Facebook page, Sir Randall Fox and the Bahamas Federation of Labor. The very first Facebook post contains a link that will carry you to a storage Dropbox where over 7,000 records have been uploaded to date. Everything has been classified to make for easy viewing. It was in 1998 that Sir Randall was interviewed by Lavad Darling, who asked this question: do you feel that the government and the people of the Bahamas recognize and appreciate the many significant contributions that you have made to the development of the Bahamas during your career? Do you feel slighted in any way? And I know why Mr. Darling asked him that question, because there was a time when people thought that he was being overlooked intentionally and that history was being revised and he was being omitted. Sir Randall replied to Mr. Darling, and he said, no, I do not feel slighted because I know that I have the power within me to make my own destiny. And with God's help, He is going to help me write my books. And as a result of my books, Randall Fox will never be erased. The word is far more powerful than any sword. And my friends here in the movement, I can only encourage you to document your story. If things aren't documented when you move on, so much will be lost. And I have not only documented my father's life, but also my mother. Very little is heard about her. But before she died, one day we were chatting, and she said to me, if there had not been a Jacqueline Fox, there never would have been a Randall Fox. And so she knew her value, but hers is another story. And I have written a book on the history and illustrated history of the Bahamas YWCA. So in closing, I would just like to leave you with his favorite Bible verse, because as this award is presented to me today, I see it as a prophecy fulfilled. He was not forgotten. And after death, so much changed for him, and his work was lifted up in God's time. His verse was, "If you have faith as a grain of a mustard seed, you will say to this mountain, 'Move hence to yonder place,' and it shall remove, and nothing shall be impossible to you." And just remember that the Bahamas Federation of Labor was a faith-based movement, okay? It wasn't just by power and might and strength. They called on the Lord. And if you get that book of mine, I'll tell you about some of those meetings that I attended. So I thank you so much. It's wonderful for me to be here for the first time at the Point, see all the lovely shops, and to see you, those of you that make up the Industrial Tribunal, and to meet you, I guess most of you for the very first time. And I wish I had time to stay to find out more about the work that you do, but my day's packed and I will have to leave, but maybe in time you can get to know me a little better and vice versa. Thank you once again.
Thank you so much. Thank you so much, Mrs. Fox. Ladies and gentlemen, we're all about understanding more about what the Bahamas Industrial Tribunal is and where it's going to go. And it's going to also consider where we've come from. And for that purpose, we've prepared a series of videos that will now introduce you to a greater concept of what the Bahamas Industrial Tribunal is all about in its transformation stage.
Welcome. The foundational strategy for the modernization of the existence of the Industrial Tribunal has its origin in the timeless truth, which we find at Jeremiah 17, verse 8. For he shall be as a tree planted by the waters, and that spreadeth out her roots by the river, and shall not see when heat cometh, but her leaf shall be green, and shall not be careful in the year of drought, neither shall cease from yielding fruit. In celebration of our 7th anniversary of modernization of the Industrial Tribunal, and in commemoration of Labor Day, we present this webinar in the form of an instructional video themed A Day of Solidarity. And this is for all our social partners in line with our annual seminars previously hosted by the Industrial Tribunal.
Management software was not put in place because of pandemic, but allowed us to be able to respond efficiently during the pandemic and to cause the continuity of the work of the tribunal while we were in lockdown. This made us, what our institution, stand out much differently from others who were not in that similar position.
That the tribunal has captured and harnessed the essence of the new digital age in its many firsts during the year 2020 and beyond is an understatement. It is something that I know certainly the Chief Justice would agree, that when implemented in some form or another throughout all of the judiciary, digitization will represent a transformative change and a benefit to the administration of justice. The Industrial Tribunal has achieved world-class standard of operations with these smart courts. These newly constructed courts have all been modified and equipped with all of the latest technology and advancements available to date. The Industrial Tribunal courts, as a result, are easily accessible to the general public and are a practitioner's delight, given the ease of use of the e-filing case management platform, as well as the capability for remote hearings. Some of the benefits of this include, for example, staff can more efficiently deal with concerns via the online message center. We know the inefficiencies of operations of remote working environments, and so this is a fantastic accomplishment. In addition, parties, witnesses, and representatives are saved the time and expense of traveling by air or otherwise to the courthouse for a trial, and prevention of parties, etc., from jeopardizing their health by having to travel to the courthouse.
The Industrial Tribunal's commitment to the discharge of its duties, provision of the services in accordance with its mission and vision statements, is again evidenced by its continued successful performance. The work of the Industrial Tribunal is vitally important to the lives of the significant majority of Bahamians, whether they are cognizant of that fact or not. As a bar association, we remain committed partners in this great work. Attorneys, legal advocates, and the self-represented alike have enjoyed the truly timely disposition of matters before the tribunal. And our tribunal has become and remains a genuine source of inspiration and national pride, reflecting our commitment to the administration of justice and the rule of law.
The history of the Industrial Tribunal. The Industrial Relations Act of 1970 established an Industrial Relations Board. The purpose of the board was as follows. 1. To hear all trade disputes relative to essential services referred by the Minister of Labor. 2. To register industrial agreements. 3. To hear any matters relative to the registration of such agreements. The Industrial Relations Act was amended in 1979 to also establish the Arbitration Tribunal for the hearing of all disputes relative to non-essential services, with the Industrial Relations Board retaining its function and jurisdiction with respect to the hearing of essential services disputes. In the case of Princess Casino versus the Minister of Labor in 1992, former Chief Justice and President of the Court of Appeal, the Right Honorable Dame Joan Sawyer, ruled in that case that the arbitration process was a voluntary process and that all parties had to consent to the arbitration process. This landmark decision resulted in the employer's unwillingness to submit to the arbitration process, amongst other things. Consequently, this led to the government's decision in light of the ensuing challenges in consultation with the trade unions and Employers Federation to establish the Industrial Tribunal pursuant to Section 53A of the Industrial Relations Act 1996. Steps to our objectives. To introduce administrative systems required to enhance the performance of the tribunal judges and dispose of cases within a reasonable time in line with the principle of due process and the rule of law. To create an environment to make justice easily accessible by establishing a user-friendly website to assist with the present administrative challenges, maintain and increase confidence, and promote a culture of transparency. To develop a database for better accountability to the public for matters that are referred by the Department of Labor to the Industrial Tribunal, and thereby promoting good relations between the relevant parties to a dispute.
On the occasion of our third annual A Day of Solidarity, 21st November 2022, we, the Industrial Tribunal, hail and salute the father of labor, Sir Randall Fawkes, as this year's honoree.
The Sir Randall Fawkes Labor Day this year was celebrated on the 4th of June. This national holiday is celebrated on the first Friday in the month of June. From street parades, cavalcades, to beach trips, Bahamians take part in many a type of gathering on Labor Day. The historical date for Labor Day was the 7th day in the month of June. Labor Day commemorates significant workers' movements since the year 1942, one such event being the 1942 Burma Road Riot, an act of civil disobedience that derived from the ill pay of Bahamians on a British military airport project. Labor Day also specifically commemorates Sir Randall Fox, a former cabinet minister who allied with the Black Progressive Liberal Party, as they were named in the 1960s, to form an Afro-Bahamian majority coalition government in 1967. This coalition emancipated the Bahamian people from British colonial rule. At the time of the coalition, Sir Randall Fox was the leader of the Labour Party. Labor Day celebrates the sacrifices of Bahamians throughout history who strive to improve the lives of workers and remedy past employment injustices.
Welcome to the Industrial Tribunal's training session. The opening of the new Smart Courts in Safari Square was October 2nd, 2020, and it was opened by the Honorable Attorney General. This training session consists of the procedural requirements for matters within the tribunal, such as how the referrals are forwarded from the Department of Labor to the Industrial Tribunal, how an originating application should be filed, inclusive of all the forms that are necessary to ensure the fair adjudication of the hearing. We also tell you about how the smart courts are set up and what makes it a smart court. We also inform you of the hearing protocols, the duties and responsibilities of the clerk of the court and secretary to the judge, and also, more importantly, the role of the judge within the hearing. There are also procedures outlined in this session for complaints made by parties in the action about the judge. And last but not least, the procedure for appeals of the tribunal to the Court of Appeal. Pursuant to an amendment to Section 66 of the Industrial Relations Act, the Industrial Tribunal is required to report to the public on the work that has been done for each year. So at the end of each year, we issue an annual report which will contain the statistics and the work done by the Industrial Tribunal.
Good morning, this is Ms. Wendy from the Industrial Tribunal. I'm calling for Ms. Jessica Jones. Hi, Ms. Jones. I'm calling to let you know that the Form A originating application is ready for pickup. You're welcome. Have a nice day. Good morning, Industrial Tribunal. Can I help?
Good morning. I'm calling to see how to properly file an originating application form.
Is the originating application completed? Under the circumstances of COVID-19, no one is allowed in office, but these are our procedures. Please ensure that you're wearing a mask when arriving. Once at the door, please buzz. A registry staff will come and assist you.
Okay, thank you.
You're welcome. Have a nice day.
The Bahamas Industrial Tribunal in New Providence is located East Street North in the Safari Square building, and our Northern Region office is located West Mall and Ponciana Drive in Grand Bahama.
Good afternoon. Welcome to the Industrial Tribunal. Under circumstances of COVID-19, no one is allowed. How may I assist you?
Good afternoon. I came to file an originating application form.
Let me check to see if everything is filled out correctly, and I'll be back with your file copy.
Okay,
Thank you.
Please be mindful that only the tribunal can issue this form. Once the form is completed, the tribunal will file this application.
Here is your file copy. Thank you. You're welcome.
What's the next step?
Now that the originating application is filed, the tribunal will issue a Form C, D, and E to the respondent, which is required to file within 14 days. Then a notice of hearing will be sent to both parties.
Okay, thank you.
You're welcome. Enjoy the rest of your day.
You too.
The Industrial Tribunal receives the trade dispute by way of certificate of referral from the Minister of Labor. A physical file is created for the dispute along with a digital file on our case management system, Attache. The referrals are also uploaded onto the Industrial Tribunal website. These referrals are also recorded in the Industrial Tribunal cause book. In accordance with the Industrial Relations Act, it is required by law to keep an updated cause book at the Industrial Tribunal. An originating application is issued to the applicant by the registry. The applicant then submits the originating application for filing. The registry will either file or reject the application. Once the originating application is filed by the registry, the forms C, Notice of Originating Application, and D, Notice of Appearance, is issued to the respondent along with a copy of the filed originating application. When the registry receives the Notice of Appearance, a defense is now issued back to the respondent. After the return of the defense, the registry will give the matter a date for case management hearing. A notice of hearing is sent to the applicant and respondent. The file is now sent to the judge clerk for calendars to be created and a virtual link to be sent to the parties. The calendar tab on our website has two features, a living calendar and a calendar archive. New Providence and Northern Region calendars are also posted onto the Attache website. The Bahamas Industrial Tribunal has 4 smart courtrooms, 1 assigned to the President and 3 assigned to the Vice President. There is a court located in Grand Bahama for the Northern Region of the Bahamas. To accommodate parties before the tribunal, the courts are equipped with cameras, jabbers, laptops, a flat screen TV, and an iPad on the bench to assist the judge. All of the equipment is necessary to conduct a virtual adjudication hearing. A virtual adjudication hearing is a recorded session and monitored by our service providers. Court equipment must not be removed from the courtroom. To assist the judge throughout the proceedings, there is a virtual clerk in addition to technical support from our service provider. Hearing protocols must be adhered all times. The hearing protocols are also posted on the Industrial Tribunal website. The hearing protocols are as follows. Pre-hearing, wear formal attire, ensure lighting is sufficient, select an appropriate location that is not distracting. Choose a noise-free location. Rename your default profile name with your first and last name. Quality control. Mute your mic upon entry. Start video before hearing begins. Disconnect audio if joining on a second device. Speak loudly and clearly if wearing a mask. Monitor the Zoom chat during the hearing for any updates. Formalities. Provide Bible for the swearing-in witnesses. Ensure parties present are clearly visible. Mute mic when not addressing the court. No eating or drinking during the hearing. Stop your video and mute your mic during recess.
The judges must refer to Practice Direction Number 1, dated 1st April 2020.
This practice direction comprises of guidance notes for conducting virtual adjudication hearings. Section 1 deals with the benefits. Section 2 deals with procedure. Section 3 with service. And Section 4 has 2 parts. Part 1, virtual case management hearings, and Part 2, virtual trial. The general notes are applicable to Part 1 and Part 2. Part 1, requester of a virtual hearing. The Industrial Tribunal proposes to conduct virtual case management hearings and trials via video conferencing link. The purpose is to accommodate the parties and the judge who agree to the whole or part of their case being heard via the video conferencing link for a virtual adjudication. The Industrial Tribunal
through the adjudication judge's clock as the host for the virtual hearing will communicate by telephone to set up the hearing and will send an email form to the parties as the requester seeking the consent of both parties to participate in the virtual hearing. The parties will reply by email with their consent to the virtual hearing by circling yes in the form emailed to them. To facilitate the virtual hearing, the parties must have a video conferencing account. They must identify the type of electronic device they will be using during the hearing and from which location, such as house, office, or other, they will join the hearing meeting. Take note that the proper court attire and court protocols are to be adhered to. For example, the form of addressing the adjudicating judge and other usual formalities that are required in normal industrial tribunal proceedings. Further, note that the proceedings are to be recorded for use as the record on a matter that is appealed to the Court of Appeal. Part 2, Court Protocols for Virtual Hearing. Environment setting must mimic and follow normal court protocols in the interest of all parties. For the video conferencing to work efficiently, only one person can speak at a time, and the judge shall take precedence. Parties must ensure that their cameras are on at all times unless special permission is granted by the judge to A, turn off the camera, or B, mute the microphone when it is necessary to speak with client privately, or C, include the actual applicant or respondent who wishes to join the virtual hearing. Parties must ensure that their cell phones are off, as in normal industrial tribunal settings, except where there is special permission granted by the adjudication judge in a virtual hearing. It is the function and responsibility of the court clerk for the adjudicating judge to set up the virtual hearing. Once the consent has been provided by all parties to the matter, the requester, through the court clerk, will forward the ID and pass number along with informing them of the adjudicating judge assigned to the case for the virtual hearing and information for the parties of the date and time of the hearing. Parties are to be in place at least 10 minutes before the adjudicating judge is expected to join the meeting. The judge has to give permission for any other industrial tribunal employee or observer to join the virtual hearing. Clerks are to have their videos off during the virtual hearing. If the meeting was to end abruptly for one reason or the other, then the industrial tribunal will communicate immediately with a new video conferencing meeting access to resume the hearing or set a new time date for the adjourned hearing. To confirm the adjourned hearing, the adjudicating judge clerk will communicate by telephone and confirm by email. The adjudicating judge in the virtual hearing has the sole authority to end/conclude the video conferencing meeting.
Thank you very much for your rapt attention. We now invite Mr. Obi Ferguson. He is no stranger to the world of industrial relations to the Bahamas. He has earned the distinction of becoming an attorney of extreme regard as he is King's Counsel. He comes now to speak as president of the Trade Union Congress of the Bahamas. Ladies and gentlemen, we give you Mr. Obi Ferguson, who will speak. Mr. Obi Ferguson.
Right.
Let me speak and get you the mic.
No one will hear him online.
And congratulations to Madam President, these distinguished judges, and all the honorable persons here today. I have to apologize, quite frankly, because I thought I was supposed to be here this morning, but somehow they had a matter scheduled to me in court for this morning, and there was a mix-up. And I said, well, I know the president will not accept me not being here. Because, just for information, the very two cases at the arbitration tribunal, I was very fortunate to have done both at the same time. I know it's a little confusing. I had a gentleman in my office. I said, look, I have to represent the people at Sheridan, and I want you to represent people at Gladstone Farm. They fired some workers. So 3 o'clock in the morning, I prepared both briefs. And I said, just go, you go down there and just present this brief, and you should be cool. And I will deal with the brief from Paradise Island. And really and truly, that is the beginning of the cases. If you do the research, you'll find the two cases. And I was able to do it because I practiced in London for about a year, just about 1 year. And the assignment I had at the law firm was to represent workers for these distinguished, established restaurants. And that's where I got my experience from. And if you notice the little brief form, nobody knew quite what to do. I actually brought it from London. And that was the beginning of the briefs, etc. I've been a labor advocate through the process. I enjoy this business. I live it every day. I see the Court of Appeal judges here. She beat up on me all the time, but I do what I have to do. So colleagues, competence is key. Commitment is key. Preparation is key. The judges will do what judges do. You can't take it personal. Don't take it personal. The judge is doing what judges do. That is to analyze, critique, and draw conclusions. Sometimes it's in your favor, sometimes it's not in your favor. The experience I had with the Privy Council, I realized how important it is for preparation, because when I got to the Privy Council, Lord Hope said to me, I need not hear from you, Mr. Ferguson. All 5 of us in agreement with you. So you don't need to ask what happened to me at that moment. Preparation, preparation, preparation. So I want to thank Madam President and the judges for allowing me to come. I have a school been going on now for about, we graduated about 600 persons in labor law. I want to continue to pursue that. I don't think anybody should appear at the tribunal unless they have gone through some formal training. They go to that tribunal and they say all kind of nonsense. And quite frankly, the judges are patient enough to put up with it. But training is important. Proficiency is important. So thank you very much for allowing me to just tell you that. And I'm not the smartest guy in the world, but I tell you one thing. I'm a very consistent, persistent, deliberate individual. I don't take anything personal. I may react, I can see one of my students in the back, Nikisha Hanna, with my firm. She now going where she can make big money. And but nevertheless, she was a good student. She did very well with me, and now she's someplace else. But remember, training is critical. I endorse Mr. Farquharson, all of his remarks, all of what he had to say. So thank you very much, and I'm gone.
Thank you, Obi. If getting beaten up by Milady Queen Scott costs you get a KT, then I know I'm not far behind. God is good. We now call upon Mr. Obi, forgive me, we now call upon Mr. Peter Gowdy, who will render remarks on behalf of Bahamas Chamber of Commerce and Employers Confederation. Mr. Peter Gowdy.
Yeah, they hooked me up already. Good afternoon. Unfortunately, Crystal could not be with us. And so I got browbeaten and I got down here as quick as I could. And yes, I'm here. So I'm here on behalf of the Bahamas Chamber of Commerce and Employers Confederation. Good afternoon, ladies and gentlemen. Notwithstanding that protocol was established, which I also adopt, I would like to acknowledge the president of the Industrial Tribunal. Where is she hiding? Over there. Hi. The Minister of Labor is probably not here at the moment. Okay, and the Director of the International Labor Organization. So, esteemed colleagues, I'm delighted to bring brief remarks, and I extend warm greetings to all of you on behalf of the Bahamas Chamber of Commerce and Employers Confederation, of which I'm a director and have been forever. But the stated reason for us convening today is the third seminar hosted by the Bahamas Industrial Tribunal, which the Chamber fully supports. However, I'd be remiss if I did not mention that the theme for today is in fact a timely one, a day of solidarity. In the not too remote past, many of us have had to be socially distant from each other, either because of the mandates or because of other reasons, all associated with the COVID-19 pandemic. However, it is good to be gathered here to fellowship and discuss matters relevant to the industrial relations in the Bahamas. We all recognize that a well-functioning industrial tribunal aids in the timely resolution of disputes between employers and employees. This only strengthens our democracy, and as such, we must all do our very best to support our institutions that are charged with protecting rights and resolving issues. As a stakeholder, the Bahamas Chamber of Commerce and Employers Confederation is encouraged by the upgrades made to the tribunal under the leadership of the president, who should be congratulated for that. And we are further encouraged by the level of stakeholder engagement, and we look forward to our continued partnership in advancing the goals associated with improving industrial relations and the resolutions of disputes in our country. The Industrial Tribunal has our full support. As I close, please rest assured that we look forward to the outcome of today's discussions, acknowledging that such discussions can be a springboard to more positive changes. Additionally, I thank the organizers for inviting the Bahamas Chamber of Commerce and Employers Confederation to participate in this seminar, and would specifically thank the president of the tribunal, together with her team, for their hard work, dedication, and commitment to including the participation of all stakeholders in today's seminar. Thank you for your kind attention.
Thank you so much, Peter. Ladies and gentlemen, you can see that we are really making fervent efforts to try to get back on time track. So we thank you for your continued patience as we brace ourselves to be really, really educated by the outstanding Mr. Kevin DeMeritt, who comes to speak to us on the economic and financial developments. Is it so that a rising tide raises all ships? Thank you. Mr. Kevin DeMeritt.
Good afternoon, everyone. I'm assuming you can see my presentation. First of all, I want to echo the words of Mr. Ferguson. He talked about preparation, preparation, preparation as a mantra. Well, at the central bank, preparation is not a mantra, it's an absolute. So here I am. First of all, I do want to thank President Francis, who used to be a demerit, for the invitation. The central bank recognizes the undeniable value of the Industrial Tribunal, as it provides a forum where individuals can have their employment disputes adjudicated by a neutral arbiter under the rule of law, what we call equality of opportunity. But today, I present this aphorism: a rising tide lifts all boats, or does it? The aphorism was made popular by US President John F. Kennedy in 1963 in a speech he gave. And the idea behind it is that if you put in place policies that improve the overall economic condition of the country as a whole, though the benefits should accrue to all the stakeholders. Is that necessarily the case? In the Bahamas today, our economy is growing. It's growing rapidly, it's growing strongly. It has done so all through 2022. Every indication that it will be the case in 2023, perhaps even into 2024. However, if you tune into any radio talk show, you will hear consistently stories by Bahamians like you and I, who talked about how difficult it is, how they don't see the benefits of this growing economy. They don't feel it. The question is, why? What's going on? Where's the disconnect? All right. So let's clarify some things right off the top. Let's be clear that we are talking about an actual growth and improvement in our economy, and then we'll talk about how it is that some of us are not feeling it, as they say. So tourism drives our economy, all right, and it is on the rise. Here is a quick snapshot. Just so we're clear, these numbers are in percentages. Right. That is, for example, if you look at the growth of cruise arrivals to New Providence this year, that is actually 1,800% growth. Right. You look at air arrivals, 88% growth. Right. Similar numbers for Grand Bahama and the Family Islands. Huge growth in absolute numbers. Sea arrivals include not just cruise ships, but also private yachts. Right. The cruise ship numbers that we expect by the time we get to the end of 2022 will be the highest cruise numbers we've ever gotten in this country, and would have exceeded the pre-pandemic levels of 2019. Right. You see here a picture of, this is Festival Place. It's no longer there, of course. It's a major construction site. But we also see already that the cruise lines have been promoting the new cruise port with their existing passengers, saying, come back in 6 months, a year, 18 months, and see, you think this is good now. Right? So we certainly expect those numbers to continue to climb going forward. Right. In addition, what we've seen with the hotels, particularly the three major resorts of Bahama, Atlantis, and now Margaritaville, they are working with the cruise line to offer day passes to cruise passengers. because what they've seen is that the cruise passengers come, have a wonderful time at Margaritaville, and then book a stay over for their next trip to the Bahamas. Right? So you have the hotels are benefiting from this process where you have the synergy of both cruise and stopover benefiting each other. And the numbers speak for themselves. Okay? What else has been going on? The second major driver of our economy is foreign direct investment. All right? And so here we are. This is just approvals granted by the Bahamas Investment Authority in terms of new projects. This is not existing projects. This is not stuff that are already underway. These are the things that are just now have been applied and are only now being approved. And you see they're scattered all over the Bahamas. Right? Whether you're talking Luther, Exuma, Andros, and going on. I'm missing one there. Let's see. Oh, there it is. The big one in Long Island that your prime minister, our prime minister, sorry, I think was at recently. But then you look at the Providence development. These are new developments, right? New approvals. And these do not count the ones, if you drive down West Bay Street now, starting at, it's what, the Goldwyn development that's just about completed, and then you keep going west along West Bay Street and Cable Beach, and you have at least a half a dozen developments that are already underway. Right. These are the ones that are responsible for foreign direct investment, providing construction jobs, so the economy is growing very, very quickly. Right. Our fiscal sector, that may be a little bit more difficult to take in. Let's make it a little bit easier. This is the results from the government's recent fiscal year 2021-2022. All right. What I want to point out here is that if you look at their overall revenues was higher than they had originally expected in their budget. All right. So their revenue outcome was improved relative to what they anticipated. If you look at their expenditures, okay, their expenditures came in less than what they had originally budgeted. So revenues went up, they didn't have to spend quite as much as they had budgeted. The result is that you have the fiscal deficit was in fact cut in half compared to 2020, 2021. Right. Every indication is that if they stay the course, if we stay the course of both revenues and expenditures, this should continue to improve. So we have tourism going up, we have foreign investments coming in, government's taking care of its part of the business. Right. External reserves, again, this may be, where the central bank tend to get complicated in a lot of these things. But the bottom line is that we have approximately $3.2 billion in what we call foreign reserves. All right. And we fully expect by the time we get to the end of 2022, we should still have approximately $3 billion. If our foreign reserves is seasonal. Usually we have, by the time we get to the end of the third quarter, going into the fourth quarter, you have companies begin to increase their stock ahead of the Christmas season. So they begin bringing in more stuff, and that causes the reserves to go down. But even so, we still expect that by the time we get to the end of 2022, we will have an excess of $3 billion. Now, what does that actually mean? That means if there wasn't another single dollar coming into the country, US dollar coming into the country, at the end of 2022, we would still have enough in the kitty that we could continue to run our economy for the next 10.3 months. All right. So bottom line, there is no threat to the Bahamian dollar fixed exchange rate regime that we see on the horizon. Good news all around. But the question is then, so what is the problem? All right. Yes, we have inflation, and inflation is undeniable. But inflation is affecting all of us. All right. All of us, when we go to the supermarket, we see the increase in prices. But that doesn't answer the question, though. How is it that some of us are benefiting, whether we're talking about individuals and businesses, are benefiting from this growth in the economy? And how come some of us are still complaining that we don't feel it? Three quick possibilities. The first is that we are unable to access the credit market. Banks have a lot of money to lend out. Banks want to lend out money. They're in the business of making loans. The problem is that they are struggling to find people to lend the money to. All right. The central bank on a regular basis conduct what we call a bank lending survey. All right. So we ask the banks, all right, how many applications did you get? What were these applications for? How many of them were approved? How many of them were rejected? And why were they rejected? All right. So that gives us an idea of what's going on. In addition, the central bank, up until August of this year, had mandated to the bank, we've done the research, and we think for the average Bahamian family, they should not commit more than 45% of your gross monthly income just to pay loans. Right? 45%. Anything more than that, then anything that happens, you're really not in a position to manage. Whether you're talking some unexplained events, you have a car accident, if you still have some bills that come due unexpectedly, you're just not going to be able to do that while meeting your normal obligations. All right. So banks for a long time have limited 45%. In August, the commercial banks came to the central bank and says, listen, things are going really good in terms of the economy. I'm sure that's no news to you guys. So what if we started making that a little bit easier for people to lend? Because remember, we got a lot of money that we want to lend out. We need to lend out. All right. So in consultation with the commercial banks, the central bank raised the debt service ratio, is what we're calling it, to 50%. Did it make any difference? Not a bit. Right. Because even at 50% debt service ratio, the commercial banks still could not find enough persons to lend money to. Right. And if you look at this chart, I'm hoping this has some clarity. If you look at reason for consumer loan denial, that big blue bar, 66% of the reasons why banks are denying application is debt service ratio. All right. We are carrying too much debt. And remember now, this is only the debt of the commercial banks. All right. This does not account the sort of off-the-books thing that right now the banks do not have any access to. This does not count the fact that you have something at some payday lender. This doesn't count the fact that you have something at some furniture store. This doesn't count the fact that you just bought this new cube off the parking lot, off the lot, and you're still paying on it. And this certainly doesn't include things like, what's that Bahamian thing where somebody's holding the pot and we all borrow? That certainly don't count. In fact, we have a thing with, we as Bahamians, we only count the bank loan in our heads. As far as we're concerned, the rest is not really loans. Loans. I mean, the bank loan. Right? We're about to have a more comprehensive credit report from a credit reporting agency. Right? And right now, the credit reports that are available to the banks only include loans from the commercial banks or loans from credit unions. Right? That's it. The credit bureau right now is working to include all these other categories of credit in your credit report, including, as we speak to this audience here, court judgments would be included in that credit report as well. Right? So what it's going to mean now is that when you go to apply for a loan or any kind of credit, you will include on the credit report will be your facilities at banks, credit unions, all these other institutions we're talking about, but and most importantly for us as Bahamians, utility companies. Right? Because we have this thing as Bahamians that we only pay enough to keep the service going. We pay enough to keep the light on. All right. We pay enough to keep cable going. All right. We pay just enough to BTC. All right. What's going to happen is that all of this is going to count towards your ability to pay off a loan. Right? And if already banks are saying 66% of the reasons why we are rejecting applications is because of debt service ratio, imagine what this is going to do to those persons looking to qualify. This is consumer, similarly for mortgages. All right. Except that if you look at here, the two major categories for reasons why banks are rejecting persons applying for mortgages. Certainly debt service ratio, how long you've been employed or underemployed, but there's a curious category here of previous loans that you skipped out on. If I'm looking at a full 16% of the reason, so you come in, you want a mortgage from the bank, and the bank is saying, well, you didn't pay off this, yeah, and you want more from us. Right? So one of the big reasons why a lot of Bahamians are not benefiting from the improvement economy is they can't access it. The other reason is that we don't save. All right? We like to talk about savings, but we don't save. All right? There's a distinct lack of savings by us as Bahamians. And secondly, even those of us who do save, and we are, I have the word ignorant here, but that sounds a little harsh, uninformed about some of the savings alternatives. Right? You can put your money in a commercial bank, and you're lucky if you have a savings account that gets you on average 0.5%, 5.5% on average. There are a lot of savings accounts in commercial banks where the interest rate is 0. All right. So if the best you can do is 0.5%, and even if you put it on fixed deposit, you get what, 1%, 1.2%. All right. That's no money. But a lot of us are unaware. You can invest in government bonds, for example. All right. The lowest is going to be prime, 4.75%. All right. And I've seen on our website just today as much as 6%. All right. That is, and the investment is not big. You can invest as little as $100. All right. The central bank is currently working with the government for the creation and development of a savings bond. Right. Another small investment opportunity for Bahamians where you can get a lot more than trying to put your money in a fixed deposit. Right. So we're not benefiting from the growth of the economy because one, we don't save, and even those of us who save is saving in the least beneficial investment that we can. Lastly, we don't budget. Oh, we like to say we budget. If somebody asks us, we can say we budget. Oh, yeah, we budget all the time. But we don't. We have something in our heads. Yeah, and that's what we take with us when we go to the supermarket. That's not budgeting. That's having an idea, a notion, right? Taking the time, going into your cupboard or your pantry if you want to get fancy with it. Yeah, seeing what you have, what you don't have, and most importantly, what you need. Documenting that, and when you go into the supermarket, sticking to that. All right. Budgeting a certain amount for your necessities, your utilities. Budgeting for savings. Savings should actually be a budgeted amount. All right. We don't do it. We need to decide, why is it necessary to always get brand? All right. Budgeting. All right. So the economy is growing very quickly. We have, in fact, because of our activities and past and present activities, we have placed ourselves out of place in being able to benefit from this economy. This is just a note on where we think the outlook for some of these things that we talked about. We're talking tourism, even though some of the external reserves, et cetera. But what I want to close with, I reworked a quote from George Orwell's Animal Farm. Right. And the thing is, are we running the risk of creating a bifurcated society? Right. Where some of us, whether we're talking individuals or firms, are benefiting from the economy, and the rest of us are getting left behind. Yeah. And does that presage something for the industrial environment going forward? All right. Because if you see as a worker, all right, persons around you and your business is all going in one direction and you seem to be standing still, yeah, you're going to feel a certain kind of way. Now, the persons in this room can speak much more clearly than I can about the inevitable result of that. Yeah. But we can all see that that is not a recipe for stability. Thank you all very much.
Thank you so much. You speak like someone who went to St. Anne's. Wow, I tell you. Thank you so much. That was such an excellent presentation. Ladies and gentlemen, to redeem the time, we're going to take a quick break. This will be a perfect opportunity for you to connect with our previous speakers and engage them with your questions. We return at 4:20. Please, if you will return, there's a lovely break outside for you. We return at 4:20 to continue there's really so much wonderful stuff ahead. So we ask you to stay and to come back on time. Thank you so much. Calling participants to the third annual opening of the legal year. Calling all participants, please return to the room. We're about to get started in 2 minutes. 2 minutes. Good afternoon, ladies and gentlemen. We are so happy to introduce to you our keynote speaker, Mr. Dennis Zulu, who is the director of the ILO Decent Work Country Program Caribbean. His beautiful resume is listed out there in our itinerary for you. Without further ado, we welcome by online surfing our keynote speaker, Mr. Dennis Zulu.
Thank you so much. Unfortunately, I'm muted. The video, I cannot turn on the video from my end because it's muted by the controller. Okay, I think that's fine now. So a good afternoon to you all. It's indeed a pleasure to be speaking to you this afternoon as we celebrate the opening of this very important new session of our tribunal, but also as we commemorate a very important individual in industrial relations in the Bahamas. On behalf of the ILO, I'd like to thank the court, especially Madam President, for having accorded us this opportunity. And we remain a committed supporter as well as collaborator with the court as it strives to ensure that justice is indeed accessed by all workers in the Bahamas. So, Madam President, please permit me to continue on the protocols as established and wish once again to express our sincere congratulations to the court for the opening of the new legal year for the tribunal. May I also express my gratitude for this opportunity to speak to you on this occasion. And today I'm going to talk about the roles of industrial relations courts in changing times. Distinguished ladies and gentlemen, as we all know, we're currently facing multiple global crises. First, the climate crisis, and we're indeed at a very critical time as to whether or not we'll be able to revert the trend in global warming and try and save the climate of the world as we know it today. We are all aware that the 27th session of the Conference of Parties to the UN Framework Convention on Climate Change, otherwise known as COP27, ended just a few days ago. And also not with the sort of expectation and practical solutions and really the finances that we need to have a concerted effort and initiative to mitigate what we all know are very adverse effects on our climate due to what is going on around the world with production and the emission of gases by mostly the industrialized countries in the world. So secondly, we're also very well aware that the peace and security crisis in the Ukraine, and this crisis itself may be taking place far from the Caribbean or far from the Bahamas, but we indeed feel the impact of the crisis on a day-to-day basis. We watch scenes from the Ukraine and the Russian Federation. It is evident that the developments out there are indeed concerned to all of us, despite being very far from it. And arising from this crisis, we've seen everywhere in the world, and including the Bahamas, a rise in commodity prices, and certain products have become scarce or indeed unavailable. And of course, we cannot forget that the fact that we're not totally free from the COVID-19 crisis, which has weakened society with its impact on our political, economic, social, and cultural lives. It is indeed a struggle as we try to recover from the COVID and other crises that affects us today. So as all these crises affect us, they obviously affect the most vulnerable of us, and these include parents, women, children, rural populations, and indeed indigenous people. They affect deep and wide, and they impact various roles that we play in society. We could be High Court justices or labor tribunal justices, and indeed employers' representatives or workers' representatives, but indeed this affects us all. Just to get an understanding of what impacts COVID-19 has had on society, the ILO did launch a monitor sometime a year or so ago, which really gave us an understanding of the extent of COVID-19 on the workplace as we know it. And its latest edition, which was released not so long ago, 4 months ago, it noted that some of the strict workplace closures that come out of as part of the preventative measures had been phased out in most of the countries, including the Caribbean, but indeed in some parts of East Asia, they did remain. The conflict in the Ukraine has increased inflation, as I talked about earlier on, and this is something we have to deal with. But obviously, what's important for us is the fact that this inadvertently leads to usually increases in wage demands. And also the heightened financial turbulence and tightening monetary policies likely to bring about a wide impact on labor markets across the world, and the Bahamas is no exception. Now, what does it mean for us, for those of us who are concerned with industrial relations and labor relations across the world? Now, usually industrial relations is where the impacts of crisis are felt the most, but they're also a device for our survival. On one hand, companies may resort to reducing their staff with a view to coping with the negative economic impacts, and this ultimately or may lead to creating tension in industrial relations. On the other hand, if the staff are retained, rehired, or even assisted for their internal and external transition, the workers would then obviously stay on and will sort of prevent any adverse effects in terms of industrial relations. So the issue really here is how do we build or strike that right balance between the rights or the requirements of the private sector, the employers on one hand, and those of the workers who provide the labor. And of course, in a situation where there cannot be agreement by these two parties, or who we call the social partners in the ILO, this is where the industrial tribunal comes in, and such as the tribunal we have in the Bahamas at the moment. And I note in this connection that the tribunal intends to do so by providing a quick and economical judicial forum and by striving to have trade disputes heard with a very reasonable time as stated in the tribunal's mission and vision. And indeed, in the presentation of our Honor the President this morning at the opening, she was very categorical and in terms of what the court has been doing lately to ensure that access to justice is provided in a timely way. Now, with COVID-19, what really happened in terms of dispute resolution? So in various parts of the world, including the Caribbean, labor dispute resolution mechanisms such as courts or tribunals did respond to COVID-19 in various ways. And for those of us at NILO, we're very interested to find out how different courts responded in terms of ensuring that their number one mandate was actually undertaken to the expectations of its clients, who, as I said, in this case, employers on one hand and workers on the other hand, as this sought justice provided for by the courts. And in doing this, I want to highlight some of the general findings that we undertook as the ILO. We did a very comprehensive study across the world, and the Caribbean included, to find out how exactly the courts responded. The report itself is very available on the ILO website, and if you want to read, which is fairly lengthy, you might be able to do this by accessing www.ilo.org. Now, this is what we saw. So in terms of physical operation, and as indeed in many other places, most of the respondent labor dispute institutions remained open, either partially or fully, and a lot of measures were taken to accommodate the fact that you had to ensure safety and security of the workers, and on one hand, and also ensuring that those who sought the services of the courts were able to access them. And the courts made various arrangements for this, either working remotely or working on site on a rotational basis. And some of the innovative tools that were used, especially on technology, and I think I'm very pleased and wish to commend the courts of the tribunal in the Bahamas for, I think, trailblazing in this regard by introducing very, very state-of-the-art technologies that facilitated continued access to the court. Secondly, in terms of the labor disputes cases, we saw that almost 26% of the respondent institutions, as I say, this was both global and the Caribbean, detected the increase in the volume of individual and collective dispute cases, especially those for individuals. And this large figure really, which is a quarter of all, can be attributed to African Americans, where this was basically the issue of concern. However, some of them reported a decrease, and some countries did report a decrease, particularly collective cases. And one common reason for the decrease was that of the closure of institutions, even if partially, did not favor resolution of collective disputes, which generally benefited from meetings and negotiations in person. Now, in terms of procedures in handling labor disputes, efforts for continuous service of the labor dispute institutions were made through changes in procedure, because obviously you had to accommodate new technology, new processes, and so forth. So technological tools were introduced to permit remote filing and management of cases and virtual hearings. And again, the tribunal in the Bahamas has done an excellent job in introducing these tools. So these tools allowed the continuation of presentation and management of labor dispute cases. They also expanded the access to labor justice as distances were shortened. And indeed, in some places in the world, the distance to accessing justice is difficult because distance and facilities do not need to be physically present in a certain area where the person seeking justice will be located. However, this access to technology was distributed unevenly, and while about 90% of institutions in the Americas and more than 75% in Europe and Central Asia had applied such improvements, over 70% of institutions in Africa, for instance, had not applied any. And the reason for this were varied: lack of resources or public investment, lack of infrastructure generally, and the lack of technological tools on the side of workers' representatives, such as access to internet and computers, were mentioned. Now, this is very important because, as we say, the parties that normally seek support or justice from the tribunals are basically workers and employers' representatives. So we saw that on the part of the workers' representatives, this was a big challenge because they did not have access to the tools needed to access justice from the tribunals. Enforcement procedures seem to have been unaffected by the pandemic because we only saw that 11% of the institutions acted to simplify or improve their procedures in this respect. The minority 17% suspended or even postponed the enforcement of decisions and awards. And lastly, our survey showed that the COVID-19 crisis did not lead to the promotion of alternative dispute resolution, such as mediation and conciliation, which was thought that maybe because of the challenges of convening would have seen an increase in this, and this was not the case. In only 12% of the institutions, measures to deal labor cases were to enhance and stimulate alternative dispute resolution mechanisms. So those, despite the fact we didn't see an increase, there was some attempt at least. Now then, what role, and I guess this is the subject of our discussion, has been the subject of discussion this afternoon, indeed this morning. So what role do industrial relations courts play in changing times? Now we see that with or without crisis, I'm in the view that the core role of industrial relations courts remain the same, and this is to hear labor and employment disputes for a fair and effective decision. The current crisis, especially the one that we're just emerging from, COVID-19, seems to suggest that the way this role is played merits improvement. And the survey that I referred to earlier on, discussed earlier, refers to the ILO guidelines on labor dispute systems, which advocated key principles of good governance on the labor dispute resolution mechanisms, particularly broad accessibility, equity and inclusiveness, efficiency of institutions, and effectiveness of their procedures. We can indeed draw lessons from the results of the survey around these principles with respect to the manner in which industrial relations court play this core role. Firstly, with respect to broad accessibility and efficiency of institutions and effectiveness of their procedures, it is evident that technical tools improve the implementation of this principle significantly and substantively. Now, in 2019, the ILO's member states passed what is popularly known and commonly known as the Future of Work Declaration. The declaration called on all member states to firstly ensure all benefit from the changing world of work, secondly, to ensure that the continued relevance of the employment relationship, thirdly, to ensure adequate protection of all workers, and fourthly, to promote sustained, inclusive, and sustainable economic growth, full employment, and decent work. And one of the 10 recommendations that came out of the declaration, which is very relevant to our discussion today, was managing technological change to boost decent work, including an international governance system for digital labor platforms. Indeed, at the time of passing this declaration in early 2019, no one knew that a few months later, the world would face an unprecedented crisis that would change the world of work. And this future of work that at the time looked very distant came suddenly. And therefore, we had to work towards improving and adapting the workplace to ensure that there's business continuity. And this, interestingly enough, did not just mean adaptation of workplace to the new ways of working, but also in the way labor disputes will be decided. And this therefore called for the introduction of technical tools. And again, hearing from the president of the court this morning, it is evident that the court has made tremendous progress in this regard. Now, the lack of access to these tools by many workers as well as businesses affected their access to justice generally. So it was not just a matter of introducing these tools or the technology within the courts, but what did this mean in terms of the actual clients, if I may call them that, who wanted to access justice. And we see that, and we did see that in the survey, that this was indeed a challenge. So those needs, so for instance, simple things like using smartphones, which are not readily available to all workers, especially those who are not in high-paying jobs, was a big constraint in this regard. So despite efforts having been made within the courts itself to put or place technology, we did see that because of lack of access by the main sort of demanders for this service, who were the workers, we didn't see any reduction in the backlog of labor cases, because then this still remained a constraint. But also the lack of technology tools may be linked to the lack of statistics on labor cases, which were observed commonly among the respondent institutions. Technology would address these issues and improve accessibility, efficiency, and effectiveness of hearing and deciding labor disputes. The need for technical tools, therefore, and their usefulness may already be recognized in industrial relations courts and tribunals, and therefore they need to be applied widely. There, close collaboration of court administrators and indeed technological specialists is essential to carry out technological improvement. And I wish to point out additionally that both internal and external users, internal being the court staff and external being the representatives of government employers and workers, must be involved in the improvement process as they're the frontline stakeholders from a point of view of technological tools, and their involvement would assure and ensure that there's usefulness and user-friendliness of the technology introduced. And this is normally the case when you're trying to introduce new technology, the fact that you need to have input from those who need it the most, and therefore it must be user-friendly to the extent possible. Now, promoting wide access to digital technologies as well as building digital competencies was key to improving access to justice. Courts could play an active role in this respect. And in addition to designing and deploying user-friendly tools, courts could hold seminars and also disseminate publications which would explain the way these tools are used and also show how to use them, but also what relevance and the sort of benefits that accrue from using them. Now, holding such trainings and seminars would actually help contribute to building relevant digital competencies, thereby improving access to labor justice. Because again, if you do not have or you do not train the users on the use of this technology, you're basically stuck in one spot and you will not achieve the sort of goals that you had in providing efficient and timely access to justice. Now, what about in terms of equity and inclusiveness? Now, efforts to implement and promote technological tools could include conscious focus on targeting relatively disadvantaged groups. And we did learn from the ILO survey that such groups would include, for instance, informal economy workers. It would also include other vulnerable groups such as women, young persons, and persons in rural areas, indigenous and tribal peoples, et cetera, et cetera. Such efforts would improve equitable and inclusive access to labor justice, which is sought out. As I say, usually in situations where there's crisis, you tend to see more cases of needing dispute resolution. Madam President of the Industrial Court and judges of the Tribunal, distinguished ladies and gentlemen, let me once again, as I end my presentation, congratulate you all for the opening of the new legal year. I wish to reiterate our commitment as the International Labour Organization to working with you and the social partners in the Bahamas to see how we can further evolve and ensure access to justice by using innovative technology and other means to make decent work a possibility for all. I thank you.
Thank you so much, Mr. Zulu. And now we call upon the Honorable Justice Maureen Crane Scott of the Court of Appeal as she renders her topic on, forgive me, emerging trends in labor decisions. Ladies and gentlemen, please welcome Justice Maureen.
Good afternoon, ladies and gentlemen. I'm not going into any of the protocols or anything like that. I will in due course mention the president and staff. My topic is going to be worded a little differently to what is on the program, but it's the same effect. It's to the same effect. My topic is resolving employment disputes in the Industrial Tribunal, some emerging legal issues. And I wish to thank the President and staff of the Industrial Tribunal for inviting me to speak at this seminar and for giving me this opportunity to share with you all some perspectives that I've gained in the area of employment law, sitting as a Justice of the Court of Appeal in the Commonwealth of the Bahamas. When I accepted the invitation, I jumped at it because maybe people know by now that I love to write. And so I set about the task and prepared a Word document which is of some length, but then I was told you have 15 minutes to deliver this topic. So I said, well, look, let me see how I'm going to do this. And so what I've had to do is to condense or try to condense some of what I have written in Word to a PowerPoint presentation and set out a few slides and try to talk to what is on the slides. And also assure you, as the president has assured me, that my Word presentation, along with the PowerPoint presentation, will at some point be available on the the tribunal's website, so that you can get the full benefit of the work that I did to prepare my presentation. And so I think now we move to the next slide. And the next slide, I've attempted to outline how I approached the task before me, which is the presentation. And so I'll do some introductory remarks, which will essentially set the stage for further discussion. And then I'll move into the Court of Appeal decisions of note, because there are very many Court of Appeal decisions. But I selected a few of them. I have 15 on the slides. And so I will attempt to speak to a few of them, not all. And then I will try to pull out from the cases in the third section of the paper or presentation the emerging issues that have arisen from the cases that I selected. I'm sure there are very many more, because I haven't looked at all the cases over the years, but I have done some recent ones. And so let's move now. So let me move on here. The Court of Appeal, as you all know, sits on appeal from decisions of the Industrial Tribunal. And so I believe you will agree that this gives members of the court a unique perspective on the work of the tribunal, and further puts us in a position to speak, hopefully with authority, on some of the legal issues which have arisen. So, some context is necessary. And so I start with the reminder that under the trade dispute procedure located in Part 6 of the Industrial Relations Act, employment disputes in the Bahamas do not reach the Industrial Tribunal directly. And so we will have to compare and contrast that with what happens in the UK. In the UK, you can approach the Industrial Tribunal, their Employment Rights Tribunal directly. You file your application at the tribunal. But here, and I imagine that it is a question of policy by the government, you file your dispute, as we've heard already, at the labor ministry with the minister. And then I suppose what happens there is the procedure laid out in the Act, where the conciliators at the ministry get to work trying to solve the problem between employer, usually, and employee. And so there's that procedural, shall we say, I imagine it's an informal process where you get the parties together and try to conciliate the dispute. Now, obviously, there's also within the law a setup where if you can't get it settled, it moves to the next stage. And so there's a referral by the minister to the tribunal, and it's only at that stage that the tribunal becomes seized of a jurisdiction to do the next step, which in the law, again, is set out. So, as I said, it doesn't reach the Industrial Tribunal directly. The Act requires that if not otherwise determined, a trade dispute must be reported in writing to the minister of the minister responsible for industrial relations within the statutorily prescribed period. After the minister has taken steps laid out in Section 69 and has failed to secure a settlement of the dispute, the minister is then mandated to refer the dispute to the tribunal. So that happens between Section 69 through 73 of the Industrial Relations Act. So at section 55 of the Act, the jurisdiction of the tribunal is laid out in the law. And as you probably already know, the tribunal is to hear and determine trade disputes within an essential service or a non-essential service. It is also to register industrial agreements relating to an essential or non-essential service, and hear and determine matters relating to the registration of such agreements. And finally, to hear and determine any other matter brought before the tribunal in accordance with the Act. And so the next section of note is Section 57 of the Industrial Relations Act. And that sets out the scope of the tribunal's work and how that work is to be carried out. It expressly provides that the tribunal shall expeditiously hear, inquire into, and investigate every dispute before it and all matters affecting the merits of the dispute. Additionally, in hearing and determining matters before the tribunal, it shall seek to avoid formality in its proceedings. It also is not to be bound by any written law or rule of law relating to the admissibility of evidence before courts. It is to make inquiries of persons appearing before it and witnesses as it considers appropriate. And finally, it is to otherwise conduct the hearing in such a manner as it considers most appropriate for the clarification of the issues before it and generally the just handling of the proceedings. Before I move into the cases, I should point out that appeals to the Court of Appeal from decisions of the Industrial Tribunal are maintainable on matters of law, not fact. So the statutory grounds of appeal as laid out in section 64 are: A, the tribunal had no jurisdiction in the matter. B, the tribunal exceeded its jurisdiction. C, the award was obtained by fraud. D, the tribunal's finding or decision is erroneous in point of law. E, the tribunal's order or award is inordinately high or low. And D, some other specific illegality not mentioned in paragraphs A to E and substantially affecting the merits of the case has been committed in the course of the proceedings before the tribunal. So those are the statutory grounds of appeal. And you can't come to a tribunal and talk about fact, because fact is what the is the role of the tribunal to determine matters of fact. But how do they do it? How do they do this? How do they determine matters of fact? And I'm going to say now, they have to do it in the context of the law, the prevailing law that they, the tribunal, must identify and apply to the case. And so, if I can give a synopsis of the tribunal's role in resolving disputes, it is as laid out on this slide. And essentially, it's now evident to you, I would think, that the tribunal's role of hearing and determining trade disputes involves making findings of fact within the parameters of its statutory jurisdiction, and more importantly, against the background of the law. And as can be seen from the decided cases, this involves the tribunal showing a keen appreciation for the limits of its statutory jurisdiction, as well as demonstrating a thorough knowledge of the legal considerations applicable to resolving disputes which come before it. And basically, this is a little segue into something that I've observed, particularly in a case that I'm going to list shortly. Increasingly, attorneys at law who represent, perhaps I should say, the employer side of things, bring a lot of complex issues relating to contract, repudiation of contract, frustration, and all these contract issues. And what starts out as a dispute, between an employer and employee becomes a mountain of legal complexity. I heard this morning, I think it was Mr. Bell, mention the complex issues that are raised, usually by the employer side, because at the end of the day, we're balancing money and perhaps a poor person who's been kicked out of a job. So essentially, I've noticed this because the arguments usually raised by the employers raise a lot of complex issues. And then if they're not addressed by the tribunal and the matter is appealed, then unfortunately, as happened in the case Evangelistic Temple, which you may read at some point at your leisure, you will see where the complex issues raised in that case were never addressed by the tribunal. And they made a finding of wrongful dismissal. And so that had to be turned back and remitted back to the tribunal for a proper hearing. And as I pointed out, in accordance with the prevailing law. So you've got this tribunal. It's supposed to be informal, an informal forum, but then it becomes complex. And and so this sort of brings about a need for the, shall I say, the tribunal itself to become more au fait with issues, to see it from see this dispute from 10,000 feet, rather than get into the weeds and listening to what they're saying about this and that. You have to be able to understand that perhaps some of these points may not be relevant to the case, and be able to address them and dispose of them in your written judgment, so that by the time they come to the Court of Appeal, that you would have addressed the issue and not overlook it, as was done in Evangelistic Temple, which is the example of how not to approach the matter. And so, my presentation this afternoon will now focus on some of the more significant cases that have been decided in the Court of Appeal arising out of the tribunal's work in resolving trade disputes, which have been referred to them under the Industrial Relations Act. So I'll highlight now a few Court of Appeal decisions also from the Supreme Court, because these decisions also guide the tribunal's work. So let me get the next slide. And the next slide attempts to list a few cases. It's about 8 there. And the next slide again follows through. So I have about 14 or 15 cases that I have highlighted. Now, my word presentation will obviously go into more detail in what was decided, what came before the court, and so on. But I will, at this stage, I think, deal with the first one, which is John Fox, Island Hotel Company Limited and John Fox. Because as you probably know already, or you may know, that involves jurisdiction. I started out by telling you what the Act says about jurisdiction. It lays out what the jurisdiction is. And the jurisdiction doesn't come from a filing in the court, in the tribunal. It comes from a trade dispute that is first filed somewhere else, namely at the ministry. And so it's the trade dispute which is referred that becomes the trigger for the jurisdiction. And so the John Fox case discussed all of this, and it's important because it involved the issue of jurisdiction of the tribunal. And the decision reinforces the statutory intent of the Industrial Relations Act that in the Bahamas, a trade dispute does not get before the Industrial Tribunal unless it's first reported to the minister responsible for industrial relations, and until it has been formally referred to the tribunal by the minister in accordance with the Act. Now, I have facts here, but those can be read at your leisure when you read the word presentation. Sorry. And essentially, the Fox case demonstrates that the tribunal's jurisdiction is crucial. It is always crucial. Jurisdiction of any court is crucial. Any tribunal is crucial. And so the lesson for litigants, in my view, is as well also for the lesson for ministry officials involved in settling disputes at the ministry level, is that litigants who ultimately want, if the matter is not settled, they ultimately want to get before the tribunal. They must raise all the points that they want to raise at the ministry level as a part of the trade dispute. Because if you only go there with a wrongful dismissal claim, and it's referred to the tribunal as a wrongful dismissal claim, you can't get into unfair dismissal. And furthermore, as the John Fox case showed, there is no jurisdiction, no ability, no power for the tribunal to amend a trade dispute that has been referred by the minister. So if it's limited in terms of a wrongful dismissal, it cannot ultimately get before the tribunal as an unfair dismissal. And so that is a message for the litigants and ministry officials who are trying to conciliate this dispute. That is an important point to remember. And then it's even a lesson for the tribunal itself to keep an eye on what it is doing. And so if senior counsel comes into court and asks to amend a matter that has been referred so as to encompass another cause of action, another claim, keep your hat on, keep your head on, and deny the application because you're being led into error. And then the fact is, when you're led into error and you proceed as you are led to by counsel, ultimately we're wasting time because when it gets to the Court of Appeal, time has passed, so many years later maybe, and then unfortunately the matter has not been resolved in a timely manner because of these errors that take place. And so that's the John Fox case. I think it's very important, and I think it is key because at the ministry level, what is actually in dispute, it has to be fleshed out, and then maybe it would even settle with knowledge of how the courts or the tribunals and the Court of Appeal views certain issues. If the conciliators and lawyers and whoever are au fait with these principles, it might settle earlier and may not have to get to the tribunal to be tried and to take up time and ultimately get to the Court of Appeal once again. So that's an important point. Now, the next case on the list is the well-known case of BMP Limited doing business as Crystal Palace Casino and Ferguson. This case is widely recognized, you all must know it already, as a landmark decision from the Court of Appeal, which clarified the law relating to unfair dismissals in the Bahamas. And I'm tempted to read it, but I won't. But what that case has determined was essentially that it's not only the Employment Act that's in play. There's a synergy between the Industrial Relations Act and the Employment Act. They are looked at as a whole, and the issues are connected. So it's both acts that are actually in play. And it also recognized the role of the tribunal as the forum for the determination of trade disputes relating to unfair dismissal. And in that case, the employer contended that the tribunal had gone outside the parameters of its jurisdiction because they read sections 38 to 40 of the Employment Act and argued that those are the only unfair dismissals that are mentioned in the law. And so this matter didn't fall within 38 to 40, and therefore the tribunal erred in holding that Ferguson had been, is it Ferguson? Yes, there's so many Fergusons, you have to remember. Yeah, yeah, that Ferguson had been unfairly dismissed. But that case has put beyond doubt that it's not only the statutory examples, I think the court said, that are found in the Act that are unfair dismissals, and that it's wider, and that the nature of employer-employee relationships go beyond whether a person was on maternity leave when she was fired, and that type of thing. So it widened the categories. It made it clear that this is a cause of action that applies to all employment relationships, and therefore it can be determined, and so it widened the scope of an application to the tribunal and/or the Supreme Court. And that, yes, I think no, this was not that one. So what else did I say I would do? There was a case of, excuse me. Thanks. So I have, in the paper, I've done some other of these cases there, but I wanted to highlight Omar Ferguson, which is another, I think, it was a case in which I was involved. I wrote the decision of the court. There were two others on the panel. But this case is significant. It comes, however, from the Supreme Court and not the Industrial Tribunal. And I did say that I would have also drawn your attention to some Supreme Court decisions because they add to the knowledge base, put it that way. Now, it provides guidance in relation to the statutory regime for claims for unfair dismissal in the Bahamas. And it provided a comparative analysis between the law in the Bahamas and the way in which unfair dismissal claims are dealt with and handled in the UK. And one of the important points in the case, I won't go into the facts there, but one of the important points in the case was ground 6, where they came to the Court of Appeal, and for the first time, the counsel for the lawyer said that the judge had no, you see how jurisdiction is important. They argued that the judge had no jurisdiction to hear Mr. Ferguson's claim for unfair dismissal, right? And they did not take the objection in the court before the judge, but they came to the Court of Appeal and were and thought that they could argue that unfair dismissal is alien to the common law, and the remedies for unfair dismissal can only be entertained and awarded by the tribunal. Only the tribunal, they said. And in those circumstances, the employer said that the Supreme Court had no jurisdiction to entertain a claim for unfair dismissal. And so in rejecting ground 6 of the employer's appeal, the Court of Appeal said, in our judgment, the fallacy in counsel for the appellant, I won't mention the name, submissions, lies in his belief that the statutory regime under the Employment Act of the Bahamas is identical to that in place in England under the Employment Rights Act of 1996. And they even brought the Cayman Islands law to attempt to convince us that, you know, the British system, which applied in Cayman, was what was in play in the Bahamas. Even, we said, as even a casual examination of both these statutes will reveal, while they admittedly create a new remedy for unfair dismissal, they are far from identical to the provisions contained in the Bahamian Employment and Industrial Relations Act. Then the court undertook a detailed comparison of the provisions of the English Employment Rights Act 1996 and the Cayman Islands Labor Law on the one hand, and the Industrial Relations and Employment Acts of the Bahamas on the other. The Court of Appeal found that the legislative arrangements for resolving disputes between employers and employees relating to allegations of wrongful and unfair dismissal in the Bahamas are completely different. And there's quotes there, but essentially, that is the importance of the Omar Ferguson case. And there's much more in the case, but I won't go there. But I think I should point out that Omar Ferguson was not dismissed for misconduct. He was dismissed because his airport security badge issued by the airport authority, which is a third party, had been cancelled. The court's findings at paragraphs 37 and 38 was that the dismissal was unfair because he had been denied natural justice, having not been given an opportunity to make representation to his employer on the severity of the decision to terminate, and further, had not been given the opportunity to appeal to the airport authority, which, as I said, is a different agency, requesting a reconsideration of its decision to withdraw his security clearance. And the findings regarding Mr. Ferguson's denial of natural justice must be understood in relation to those peculiar facts. Since Ferguson, I gather, there's been a plethora of people saying, look, natural justice, natural justice, natural justice, I've been denied natural justice. But the facts of that case are that he was not dismissed for misconduct. There's a whole regime for dismissals for misconduct, as we all know. And so that case has to be, while it is useful, it has to be looked at in a different light. Now, since Omar Ferguson's case, the Court of Appeal has had occasion to clarify the role played by natural justice in employment disputes. And there are the cases of Sherry Jennifer Brown, Bahamas Electricity Corporation, and another, and Sherry Jennifer Brown, and Paul Major and the First Caribbean International Bank. That is reported in 100 West Indian Reports, a 2022 case. And again, this is another Supreme Court case, but the principles laid out in the case will guide the tribunal and the vice presidents and president. And it's crucially important because it clarifies once again the law governing claims for wrongful dismissal and unfair dismissal on the one hand, and the employer's defense, because it's usually a defense that the employee had been lawfully dismissed in accordance with the summary dismissal provisions in the Employment Act. And so I think as I skim through here, in the Paul Major case, again, the Court of Appeal conducted, again, a comparative analysis of the unfair dismissal provisions of the Employment Act and the England and Wales Employment Rights Act, and considered whether the judge had failed to give proper consideration to the question whether the rules of natural justice had been breached. And so the court was forced to look at our legislation and to determine whether this concept of natural justice could be found anywhere in the Employment Act or even the Employment Act anyway. And essentially, we pointed out that unlike Section 98 of the English Employment Rights Act, where there is a specific reference to equity. In that act, the test in the Bahamas, as you probably know, is that Section 35. The question whether question whether a dismissal is fair or unfair must be determined in accordance with the substantial merits of the case. The case of Sherelle Cartwright, I think it was John Isaacs pointed out, along with the panel, that is determined by making a factual inquiry. But when one looks at the Act, the Employment Act, the Court of Appeal pointed out that the fairness principle in Section 98 has a reference to equity in addition to substantial merits of the case. In the Bahamas, we only have the concept of substantial merits of the case. So the word equity is not provided for in our Section 35. And so we said, unlike Section 98 of the English Employment Rights Act in the Bahamas, the fairness principle in Section 35 contains no reference to equity. Furthermore, nothing in Section 33 or 35 expressly, and I say expressly, requires a court or tribunal to have regard to natural justice or the audi alteram partem rule when determining whether an investigation is reasonable or unreasonable for purposes of summary dismissal, or when considering when a dismissal is fair or unfair for purposes of Section 35. Whether a dismissal is fair or unfair will always depend on, in the case of a claim for unfair dismissal, the substantial merits of the case, which will include an evaluation of the circumstances of the dismissal and its reasonableness or otherwise, and an overall assessment of the fairness or unfairness of the dismissal based on this factual inquiry, which must be undertaken in each case. What I've observed is that when the claim is a wrongful dismissal claim, you usually don't have a problem because you're looking at Section 31 and 33 and going through the statutory issues. But when the claim involves and/or unfair dismissal and unfair dismissal, because the claim can be, I've been wrongfully dismissed and I have been unfairly dismissed. When you have both of those types of dismissals included in pleadings or included in your originating application, that is where I think there has to be a bit more care from the point of view of the tribunal and or court in not conflating the two, because many of the grounds of appeal that come before us in various cases allege that the tribunal and or judge conflated the issue or the tests for unfair or or what is the other thing, wrongful. And so that is something that has to be borne in mind by a tribunal that is hearing a claim that involves hearing a matter that involves both types of claims. And there are, as you could see, there are a number of other cases. The second slide has a number of other cases that I've highlighted, and I think that I think that you should get the word paper and attempt to look at some of what I've written, and or go to the cases and see what is decided there. But there's a last case, a case of Westech International Security and Jason Tynes. This is an industrial tribunal case. It was decided, and actually the court's decision, Court of Appeal decision, was handed down this morning. And I was interested when I heard Mr. Farquharson point out some of what the employers may be doing in the field. Because in this case, when this gentleman was recruited as a security guard at Westec International Security, he, in order to get a job, had to sign a paper, which was their code of policies or whatever it was they called it. And the poor gentleman had to sign something to the effect that this company does not pay overtime. And so he sat there, so he took the job and he did whatever he had to do, and he never complained for 4 years. And then ultimately he was terminated. He was terminated for, what was it now? I can't remember. Some infractions that they terminated him for. So Mr. Tynes was not deterred. Mr. Tynes did not complain about his dismissal, but he came to the tribunal, to the ministry, and lodged a trade dispute complaining that he had not been paid his statutory overtime for the 4 years that he had been employed with these people. And ultimately, he went before the matter was not settled at the ministry. It came to the tribunal, and the tribunal determined that he could not contract out, because obviously, when you get there now, the lawyers come out and they're going to say, but you contracted out of your statutory right to overtime. And so why are you complaining? And I think you should read both the decision of the tribunal, which I thought was very well done, as well as the Court of Appeal decision. The tribunal went into issues such as, can an employee contract out of statutory provisions, traced a number of cases from Commonwealth and wherever, and essentially said that where you have a statute that has public policy in it, right, where you have an imbalance between power, usually you cannot contract out of those types of provisions because that is what Parliament wants. And so, but when it got to the Court of Appeal, the issue was not as mundane as that, but what was argued, and I think you should listen to this. Ground 2 of the appeal raised a very unusual issue. Essentially, the employer contended that notwithstanding the clear intent of sections 4 and 10 of the Employment Act, the tribunal's award of overtime pay to Mr. Tynes erroneously interfered with the parties' right to freedom of contract enshrined in the International Convention on Economic, Social, and Cultural Rights. So think about that. They argued very strongly before us that we should strike down. Can you imagine a Court of Appeal being asked to strike down provisions which the Parliament of this country put in place for the benefit of employees? But nonetheless, it was done, and we were shocked, but nonetheless, we listened. And ultimately, if you read today's judgment, which should be posted there now, you will see the reasons why a country cannot, even though you might have adhered to ratified conventions, conventions don't become domestic law unless Parliament makes them so. So in this case, the Employment Act was in place long before the Bahamas joined what is it now? Convention on Economic, Social, and Cultural Rights. And so we pointed that out, and hopefully that becomes a lesson to other employers. I don't know if it will, but Mr. Tynes got his money. And so right now, I'm not sure whether I should. How much time have I got? Have I gone over my 15 minutes? Well over. Well over. I have to end it? Very well. But I was going to summarize in bullet form some of the key points that came out of the cases in there. But you will get the presentations. I'm told that they will be posted on the website, so just go and look at them. And that's my presentation this afternoon. Thank you. Yeah, so just let me finish it because I didn't finish it properly. Sorry. There is one paragraph that I wanted to read, which is the final paragraph. So in conclusion, ladies and gentlemen, my view is that the process of resolving employment disputes in the Bahamas is working quite well. The process operates at two levels, namely at the level of the Industrial Tribunal, as well as in the Supreme Court. When called upon on appeal to review decisions emanating from the Tribunal and the Supreme Court, the Court of Appeal ensures that any errors in law in the process are corrected, the relevant statutes interpreted, and the necessary guidance given to ensure that the law is applied as expected in the settlement of existing and future disputes. So with that, thank you for your attention. Help me down.
Justice Creed Scott, that was awesome. That was amazing. Thank you so much. You touched on so many, and I'm going to get that white paper and review those cases. Thank you so much for sharing. Ladies and gentlemen, we now call upon the chairman of the National Tripartite Council, Ms. Sharon Martin, who will come to speak on the National Tripartite Council, a national social dialogue institution and initiatives based thereon. Please welcome Mrs. Sharon Martin as she comes.
You know, when I was president at the National Insurance Board, president of the Union of Public Officers, I had the opportunity to, of course, represent the workers. And so I would, get in contention with this one lawyer. And one day he looked at me and said, they're bush mechanics, and you're a bush lawyer. So please, Mr. Photographer, please take my picture with all these judges, and so that I can post it to let him know that I am now an official lawyer by osmosis. So today, what is the win for today? What are we going to discuss under a national social institution, NSDI? They know me, and I love acronyms. NSDI, NTA, NTC, that sort of stuff. What is today's win? When you leave here, what do I expect to happen? What do you expect from me? And so I want to introduce the National Tripartite Council to you. I also want you to know what is decent work. You're hearing these words been thrown around. What is a decent work country program? DWCP in the Bahamas. And qu'est-ce que c'est? What is NSDI? Lastly, the effectiveness of NSDI in the Bahamas. And we don't have time for questions. So who are we? If you say Valley Boy, I go back to my seat. Who are we? Who is the National Tripartite Council? So let me just say the actors, the composition of the actors in the National Tripartite Council. There are 12 of us. I see 1, 2, 3. Just raise your hands, those of you who are left in the room. Thank you. Those are some of the council members, and they come from either the government, the employers, or the workers rep. We are very unusual in that most boards wait for an election or something and then they're changed or they're put in place. We are a very different creature in that the National Tripartite Act gives the stakeholders, the social partners, the right to have the composition of these members. So, President Ferguson, please raise your hand, wave back, Mr. Dwayne Woods, President Dwayne Woods. These men would then send their union reps. They have to send 4 persons. 3 persons are voting members and 1 is an observer. But of course, we swap out at times to allow persons to take a vote on something that they're either passionate about or they're more knowledgeable about. Most of the times I step out of the room and let them do the thing. No, I'm not joking. Governance, 3 years. We are in place for 3 years. And our election of office is again different. So the government nor the stakeholders appoint a chairman or the officers. We go into an election, an internal election, and then we do just like every election, you lobby and whatever, and the best woman wins in this instance. And so that's how I became chairman. I won my seat. And made history, of course, as the first woman to be a chair or to lead the National Tripartite Council. We talked about this, you've heard these words, and I'm not going to spend time on this because you need to invite me back so that I can go in depth in talking about what is decent work, what is the Decent Work Country program, and all that it entails. Okay, because that is a separate animal that we would take a day just to go through. So I am not going to go into these aspects, but you must attach those words when you hear the National Tripartite Council. The idea of the Decent Work Country program, as I said, that we're not going into, because I want to strip a layer off of who we are. At times, you're just getting familiar with hearing the National Tripartite Council, but there is a part of us where within the social dialogue concept that I don't want to discuss. The Decent Work Country program is online. It is also a priority number 2, that we would have agreed to in the Decent Work Country program. However, that social dialogue is a different component of where I want to go today. And what I want to do is I want to talk about the NTC as an effective NSDI. We are primarily a policy-making body. So I think it's Mr. Demerit. I had words with Mr. Demerit when he came off stage. Mr. Demerit, I wanted to go on stage and ask you, where were you when they were beating me up about minimum wage? I needed that solid voice. And I told him, Madam President is going to hear from me as I tell her to send this message to you. Because these are the things that we do. We make policies. We would have just completed the minimum wage, increasing the minimum wage, and we got beat up for it. And some of the questions was, why now? Well, you heard his presentation and you heard that the country is in a robust, notwithstanding the inflation. You saw it yourself. The numbers are there. And so we have this hope that exactly what you saw today will continue to happen. The country will continue on its pathway so that we can just reach a hand to those persons who we would call the living poor. Because actually, if we had not raised the minimum wage, and I'm going to tell you this because a lot of you know the facts because of your profession, those figures were 2013 figures that we raised. This is 2022, but we could only go to that point in 2022 by using 2013 rates. It breaks my heart, and so you will find that the National Tripartite Council will be calling on you because we are trying to ensure that we send all our bills through you for public consultation. And when you get it, would you please kindly read it and get back to us? Let us know where we need a little help, my friend. So let's talk a bit about an effective NSDI. Let me get my notes very quickly because I want to stay just a few minutes. And, you know, Madam Judge, I was just like you. I prepared for half an hour, and I figured somebody would drop out and I would get their slot, you know, and then I would just do my half an hour. I was trying to give you my slot actually, but Madam President would not have it. So let's talk a little bit about an effective NSDI and what happens. So we have an agenda setting, and I'll explain that to you because I need you to take out your phones and I need you to Google right this very minute, Google the National Tripartite Council Act 2015. Quickly Google on your thing. As soon as you get it, raise your hands and I'll move on. If you don't have Wi-Fi, then I bought my own Wi-Fi. I wasn't playing, not knowing. Are you ready? Ready, good. So the National Tripartite Council Act 2015, and you can bookmark that, please, because you will be needing it a lot. As I said, we will be doing public consultations and we will rely on you, but this is your benchmark. The Act allows us to set an agenda, but this agenda needs to be set with the tripartite body. The government doesn't sit by themselves, and this is where people do not understand how governance runs in a country. They think that the government eats bad pizza and wake up the next morning and make decisions. The night before they eat bad pizza, the dead saints. No, that is not how it works. In every forum, as it is in labor, the National Tripartite Council Act says to the government, any government, every 3 years, you need to tell us what you want to see done in labor. And that's what we do. We write a letter and we say, now it's 3 years. We need to know what you need to do. We need to set the agenda. You heard the Prime Minister allude to it this morning in his speech when he spoke about the fact that the National Tripartite Council would have met with Cabinet based on Cabinet's decisions, mandates that they sent to us. And the agenda was set between the tripartite body. It doesn't mean that the government alone had a say in the agenda. It meant that the BCCEC, who is the leading body to cover the employers, and the NCTUB and CBTUC, those are the unions, who would also have sent their agenda setting as well. And we sit down and we decide what goes on the agenda. Let me tell you, most of our agendas are aggressive, very aggressive. Your president, Madam President, will let you know. Unfortunately, I don't know what happens to me. I don't sleep. They don't sleep either. And something happens when I want work to be done, and I call and somebody tell me, but I'm not feeling well. And I said to Madam President, so? I mean, are you going to concentrate on not feeling well, or are you going to concentrate on ensuring that I speak with you and I get some clarity on where we're going and what I need to do and how I need to do what I need to do? Because it needs to be done. And so Madam President, sick or not, did what she needed to do. She had a conference with me as I needed. And so unfortunately, I don't know, it's something is wrong. Then we move on to the policy formulation of what, and this is the exciting part for me, how we get together and how we put together the formulation of a policy. Usually though, the policy formulation and the decision making actually wraps itself into one big ball of us making sure that things happen. But it all reels back right into what you have on your phone, that we have to abide by those points in the act. And we try our best not to deviate from the law. The law is actually our friend. Policy implementation, and now we're adding in monitoring and evaluation. You know why? Because as Bahamians, when you go to these international conferences or somebody asks you for data, there's nothing, because nobody wrote a report, nobody took the time to look at a policy and say, is this good? Is this helpful? Should we not do this? And that's what happened with a lot of stuff, and it goes by the wayside because there is no monitoring and evaluation process. So the National Tripartite Council goes through those 4 points whenever we are talking about making any determination on any policy that we have before us. We have the National Apprenticeship policy that now that we're working on to ensure that there is some national guidance for apprentices in the Bahamas. And we're working on quite a number of projects, including your very own tribunal court bill. And we will, on Wednesday, I can announce that we are sending out the links right now for a Wednesday morning consultation. Please take the link when you get it, and please come on. It's all virtual. So that is the policy cycle that the National Tripartite Council goes through for anything that is placed before us. I want to say that if you look, let me get a commercial break. Brought to you by Tide. If you look at the diagram before you, you will see all the things that we have to go through in order to come up with the solutions. And that's what makes the effectiveness. Excuse me. My 2 minutes. I'll just show you quickly some of the national projects that we're working on. And all the projects that we work on, we also try to ensure that the national development priorities are captured, along with the international SDG goals, that they're all captured. Minimum wage, as I said, 2015, 2022. Prime Minister would have been there at the launch at the DWCP, Director Zulu, and this is where they would have been making the signing. Let me go back a bit just very quickly on this one. Do you see the persons who are seated at the table signing that memorandum of understanding. It is not the government by themselves. It is a tripartite body. The top photo will show you the unions and the BCCEC and what that we call the social partners. And then the bottom one, you'll see government signing, which is the Prime Minister and the Minister. Signatories on the Decent Work Country program, which are the persons that you saw in the photo. This is one of the programs I spoke about that we're currently working on now. And there are times that we need to call on you to sit on some of these projects. When we are crafting the bill, we don't draft bills. Even though I have those two right there, wave again, those are lawyers in the Tripartite Council. Go ahead, Ms. Yallop and Honorable Rionder, wave again. Yeah, yeah, they don't draft bills. So we need the people who do that. Help us, please. Thank you very much. And like us on Facebook. And thank you. It was a pleasure.
Thank you, Madam Chair. Ladies and gentlemen, as we speedily move along, we call upon Mr. Belville Wooding. He is the genius behind the innovation and the technological advancement that we have enjoyed at the Industrial Tribunal, and he will lead our panel discussion, comprised also of Mr. Richard Wall, Mrs. Blakaris Carr, Mr. Ken Lightburn, and Mrs. Almitra Jasmine Colley in short course. Please welcome Mr. Bevel Wooding as he comes.
Good afternoon, everyone. Protocols having been established, I now am the boundary between us, the last panel, and our social event. So I will abbreviate my presentation, but I do want to get some important points over to you. Let me start first by sharing a bit with you about the Caribbean Agency for Justice Solutions. I'm standing here as the Executive Director of the Caribbean Agency for Justice Solutions. And for those of you who don't know, it is the only agency in the region dedicated to providing technological solutions for what we call the justice sector. An interesting thing about that is that for many people, the notion of what is the Caribbean justice sector is still something that has to be defined. And so for us, our tagline sums up the position that we're taking, which is in service of justice. And the justice we serve does not begin at the courts, it does not begin in the law, it begins in the society. And it is for that reason that we pay particular attention to the role and function and value and importance of good industrial relations and employee relations, because that's the initiation point or the touch point between so many of the disputes in our region. And so the honor is mine to speak to you at this third annual Day of Solidarity. And I do want to share with you a topic that has been a point of great interest in recent times, and particularly as a result of the pandemic, and that is this intersection between technology and industrial relations, or as the title says, industrial relations in the digital age. And we are this curious junction where no one can argue that the times have changed. Some years ago, presentations might say times are changing. Technology is going to have a certain impact, but we are now in the this is that dimension where the change and the industrial relations across the region and even around the world are now inextricably linked. And we have heard from speakers both at this morning's launch of the new law term and the speakers here today about dimensions of this intersection. the, tri- the change that has been triggered by the technology of today, whether it is social media, whether it is access to the internet, whether it is the devices in the hands of the old and the young, um, they all create the best change when the dynamics that they trigger or that they create are in alignment with or are congruent with the respective power and policies of governments, corporations, managements, unions, and civil societies. Now, it's an easy statement to make, but here's a trick inside of it. Most of those stakeholders aren't particularly concerned about the developments inside of the other silos to help adjust or bring that balance into perspective. And so you have this situation in which technology is touching everything, is literally changing everything, but the way in which the interplay between these various segments of our, let's call it community, civilization, or society take place is not well understood. But for us to be effective in the execution of justice, we have to understand those linkages. So let's talk a bit about the connected social. And I'm sure many of you would have heard the term digital natives and digital immigrants. The revolution that we're inside of, and you can read the cartoon where the child is at the keyboard saying, I'm a native, which means I was born into this technology. And many of us, whether our kids are teenaged or younger, would know the very distinctive characteristics and traits of those for whom this is now second nature, an extension of self. I think about a question, my mind instinctively causes my hands to go to a search engine to get a result. Versus those who came out of a previous era in which that is a, well, I wonder what's the answer to this, and then you call or you search for it yourself. And in a very real way, the digital revolution has produced a new type of human being. These digital natives have a new type of social consciousness. Now, remember our topic, technology and industrial relations. And industrial relations at its core is the interaction or interplay between people, the organizations they're part of, the dynamics between their various interests. And if these interests change without us being mindful of what is triggering the change, and I'm sure for many who sit in either the tribunal or at the courts, you see a dichotomy of opinion and understanding when it comes to the triggers as to why people do what they do and their connection or mooring inside of what used to be societal norms. And that's what we want to look at. So if we're in this connected social, we can see a real digital generation has already arisen and is arising that is imbibing and manifesting values and behaviors that are not always congruent with our local traditions and norms. And I have an image on screen which may be familiar to many of you. And sometimes for those of us in this room, if I average the age, you look at these dress codes and you ask yourself, why? Why? I have seen across this Caribbean in some of the hottest capitals, and I mean hottest literally, capitals of our Caribbean countries, people wearing hoodies and sweaters because it is in vogue. Where are they getting these appetites and interests and inclinations from? And all of that is part of the connection inside of this connected digital native generation that is arising. And what it is doing from an industrial relations standpoint, if you think of it as a group that is significant in our society and emerging into places of influence and power, getting their input and influence from sources that are no longer just local or no longer just cultural, coming into understandings and perspectives about what is their right and what is their privilege that may or may not be connected to what the laws say or what the tradition was. Then we can use this familiar English term and say we now have to mind the gap. The gap between these expectations and the offerings that we're providing in our workplaces. The gap between these perspectives and the conditions and the policies that have come out of a previous era that a generation is now saying, well, we no longer wish to subject ourselves to these conditions, even if they signed a contract saying that these are the conditions. And so a big part of negotiating this gap is managing the frustration between those two polar views or standpoints. And that is the IR challenge or the industrial relations challenge. How to reconcile employee expectations with business and service environments and labor policies and laws that were crafted, formulated, or considered inside of a different context. And we're seeing that when it comes to technology, we can have a conversation about technology in the workplace or technology in the courts or technology in some of our institutions. But the start point for where technology is really hitting and impacting us is technology in the hands of individuals. And the impact that that possession of access to knowledge and cultural patterns and behavioral norms, how that is shaping the reaction and response of those who we are now seeing coming into our workplaces, coming before our tribunals, and appearing before our courts. Everybody with me? That's the divide that we're trying to mind. We found, if you look at a list of the things that are impacting uh, the, the workplaces of today, many of these boxes will be familiar to all of us. Social media playing a huge role. We have seen both from external news reports and here at home the impact it has in mobilizing communities of interest. Right? You have one man who has some ought with an employer and he does the right thing on the social media challenge, and all of a sudden you have a protest outside of your workplace. Right? He no longer simply has to rely on friends and family to come and support him. He can now call upon the tribe. And these things are changing the dynamics in real ways. We have workflow automation causing people to become more anxious about their place inside of organizations. Are you going to let me go? Am I going to become redundant because this new shiny digital toy is now part of management's priority? And that is shaping, again, the behavior and reactions. Robotics doing the same thing, artificial intelligence on the horizon, but very much in sight as it relates to the perceptions being formed by media about what these AI tools can and will do. And it's not always the best picture being painted. So you might have an opportunity in a workplace to leapfrog competition, to expand to new markets on the basis of AI. And just the term falling into the ranks of your union members or your unionized environment or inside of the ranks of your employees can trigger fear and anxiety because of the connotations associated with AI. So when you look at these boxes and when you look at these trends, you see that we really are inside of changing times, where things that on one side can and should be positive, there's a flip side to it in which it can also be damaging and deleterious to our environments and to industrial relations. And that's the thing I want us to bear in mind. We don't have time to, of course, drill into any of these points, but I do want to highlight some of that flip side of the positive things about technology in the workplace. So everyone knows costs go down, productivity goes up, it enhances efficiency, and all of these wonderful promises of technology. But there's another side to the coin in which there's management or worker apathy. I don't know if we really need this here right now. I don't know why they don't spend that money on giving me more vacation pay or more bonuses at the end of the year. You have cultural conflicts. Are we really serious about removing these persons from the front line to replace them with computers? You have technological illiteracy. I don't know what this is about. I don't know how to use that thing you just brought onto my desk. You have staff and customer resistance. I prefer to talk to a teller, please. I don't like talking to a machine. You have technology failure. They said it was going to work and make life better, but it's always down or the internet is too slow. And then you have the very real cyber risks. Are we going to get hacked? Did we get hacked? How are we going to respond after we get hacked? And all of these things form a frame in which people are interpreting the push, this inexorable press toward automation and digitization. But it's coming with real anxiety and real perplexity around what does it all mean. And if we're not equally collaborative in our approach to explaining what it all means, if it doesn't come with a sufficiently rounded narrative around the impact and importance and integration into how we do work and how we interact as teams and as industries, then you can find that these disruptions cost you your business or cost you your jobs. And so the key in any evolution is not the technology, but the way in which people choose to use it. And that's how I want to leave us as we go into this panel discussion to discuss the various perspectives from private sector, from the tribunal, and from the agency itself on how technology is working. Technology itself is never really the reason things change. How people choose to apply technology has always been and will always be the real catalyst for the development that we seek. I leave you with those words and a slide from one of the presentations that was running at the break. For us at the agency, and I put it out to this room as well, we choose to use technology in a way that champions the cause of justice. We apply it in a way that allows those who don't have a voice to have an amplified voice, and for those who don't have an advocate to find methods and avenues for getting their matters heard expeditiously and heard fairly. So these same principles I'm saying also apply to how we put technology to use inside of our institutions and organizations. So with that, I thank you and turn you over to our panel. All right, so we have Mr. Richard Wall, I think is online. Richard, can you hear us?
Yes.
Okay, Richard will be our virtual moderator for this session, and there he is. This is Mr. Richard Wall. He is the Chief Technology Officer at the Caribbean Agency for Justice Solutions, and he will introduce the panelists and carry them through a very concise discussion on these issues. So I turn you over to you, Richard. Thank you.
10 minutes. All right.
Mm-hmm.
10 minutes.
Not 10 minutes for your introduction, 10 minutes to the panel.
Thank you, Bevel, and good afternoon, everyone. So our topic to cover today is the Industrial Tribunal at your service. And we're going to dive in a little bit into the technology and some of the benefits that has been experienced by the panel themselves. On the panel, we have Mr. Lightbourne. He's the Vice President, Labor at Atlantis. We have Ms. Colley, Corporate Counsel at Bahama, and Ms. Kerr, Manager of Online Services at the Tribunal. So I'd like to dive directly into it. We've heard quite a bit in today's two webinars. We've heard about the Courier Court Management Suite, the Folio e-filing portal. These are all tools that have made the digital transformation at the Industrial Tribunal very successful. We've had the attaché case management system. These are words that you've been hearing and systems that different speakers would have mentioned. The Sightlines Performance Toolkit came up in one of the videos as well. Smart Court and online sessions. We saw the Diva service here, which is a dedicated internet virtual assistant, and as well as Snaps, our SMS and online notifications. So there's several tools, but what we want to get into is a bit of the impact. And if I could start off with Mr. Lightbourne. As an attorney, how has the Industrial Tribunal digital transformation initiative impacted your work? If you could give us some insight into how the technology actually touched an attorney, how it transformed how they did day-to-day operation, that would help get some insights into it.
Thank you. Thank you. Good afternoon, everyone. Good night. we always hear the saying that justice must not only be done, but it must be seen to be done. In this case, justice has been seen, and that is because of the effectiveness and the thoroughness of all of these cases that are coming to the tribunal. What do I mean by that? When it leaves the Department of Labor stage, it moves quickly into this process or this online process that we use on a regular basis. And one thing for us at Atlantis, me and my team, we are able to review those cases as they come through the track by way of the original application. We can review it fairly quickly. And once we are added as an attorney to the case, then we can upload all of our cases. So it's very quick, it's very, very thorough, and we're having fun using it.
All right. So that's a big part of the e-filing portal that Mr. Lightbourne spoke about, giving users full access to their cases, documents. They have full control. Obviously, the tribunal will moderate and provide security access and things like that. And so that technology is now in the hands of the attorneys to be able to access their cases and continue to upload, moving things much faster. I'd like to go over to Ms. Colley. Can you identify some of the efficiencies gained or your similar experience from this digital transformation exercise that would have benefited you and your team?
Thank you, and good afternoon to everyone. I remember on July 31st, 2019, when I was part of the first training session, and there was much trepidation. I was shivering in my boots on whether I would be able to handle this technology. And so I was one of those persons that had to work at it. But finally, I got the hang of it and quickly saw the benefits of the eFolio system. One in particular is cost. It's very cost effective. There was a time when I charged my company, each time I went down to the tribunal to file documents, I charged them for gas. Sorry. I charged the company for gas. And so now I can just sit back in my desk and go to the scanner and quickly file, so I no longer get my gas mileage allowance. So it is very cost effective. It's easily accessible, so I don't have to fly down to the tribunal and get there for 4 o'clock anymore. I can, from the comfort of my office, file documents, scan them, file them, upload them. It's very accessible, very easy. I can access um, the system weekends, holidays, and even when the court is not in session. So it's super easy for me now that I've gotten the hang of it, and I'm no longer afraid. It's a beautiful, innovative tool that the tribunal has instituted.
Thank you, Ms. Colley. And one thing to note there as well on the costs, we've seen a significant reduction in paper costs as well, because that would decrease significantly everything now, including the submission of documents by the attorney. The viewing is all done digitally, as well as the tribunal, the judges, registry staff is viewing those documents online. I'd like to turn it now to Ms. Kerr, who is inside of the day-to-day operations of the court and using a lot more of the tools. We've been kind of focused on the folio e-filing portal, but Ms. Kerr would be more familiar with some of the others like case management, the sidelines performance measurement, the smart court. Kerr, can you identify what you would say are the success factors that you would attribute to the success of the digital transformation exercise?
Good evening. Good evening, everyone. So some of the things that we've been successful in doing by implementing all of the tools that we use currently. First of all, tracking files. We're able to track not just files, the physical file, but the digital file allows us to see everything that's available to not just the registry, but also to parties. And I think it builds the confidence of the parties to a matter in trusting that the process is working. I think one of the other tools that has been extremely successful in our smart courts is virtual hearings. Virtual hearings allow parties to join from anywhere at any time. And so the need to rush into court or the need to be physically in the country is eliminated. You're now able to handle a matter at any time. So, and I think Mr. Lightbourne could agree that it was extremely successful and useful during the times when COVID was still, concern, people coming into court. We were still able to carry on with court. And so you have litigants who are waiting for their matters to be heard and dealt with. They don't have to feel as if a delay because you can't come into court because lockdowns or maybe just concern about transportation location. These things are in some way eliminated by the use of our virtual courts.
All right. Thank you, Ms. Kerr. And thank you, panelists. I know this was short. We had a short window, but I think it gave a good view, a good peek into some of the transformation that took place and how it impacted individuals that's using the system. I'd like to end by thanking President Francis and the VPs, as well as the registry team and everyone that has been working with us to make this a success. And congratulations on this event. I'll turn it over with the extra time. I'm going to yield my time so that you have an extended cocktail time because we finish, I think, a little before. Thank you all.
Very well. Thank you. This brings us to the end of our sessions. We want to say thank you, but we do have a few items. I'm going to ask the assistance of my colleague, Mrs. Ingrid Cooper Brooks, very, very quickly. And we will ask our presenters to come forward. If I may call upon Madam Scott Crane. Scott. Madam, and if you will come here and then we can get.
Shaky knees.
My pleasure. Miss Helen, if you can assist me, please. If you stay right there so we can get all of our presenters. And now, Mrs. Sharon Martin, if you will come, please. Yeah, take it, go straight up. Yeah. We will call upon Mr. Bevel Wooding. One of them will like. We'll call upon Mr. Morgan Graham to receive on behalf of Mr. Farquharson, who is no longer here. Shirado, if you would join us, please.
Who's the next person?
Mr. Demerit?
He left.
So we'll ask Ms. Shirado to accept on his behalf, and we'll make sure it gets to him.
Move this slide.
And I have the pleasure to present to Madam President. Ladies and gentlemen, all the video presentations have been downloaded to the Bahamas Industrial Tribunal's website. Please feel free to avail it. There's a party outside with your name on it. We ask you to the party to the break of dawn, as the song goes. See you next year. Thank you. Oh, forgive me. We will take a group shot, and then we party to the break of dawn. Please, if you will come forward.